Shall judgment?
May I mention a case, Your Lordship, from the list, Your Lordship?
For what? For what do you want to
Your Lordship, serial number 25, Your Lordship. In this matter may be heard, Your Lordship, before I. Matter relates to the compassionate appointment, Your Lordship.
Main list?
Main list, Your Lordship.
We will try. Call kariye.
Your Lordship,
Judgment
from
report.
supplementary serial number 16.
May I give a slip outside the list?
From bail list for judgment item 1, criminal region 17 of
What were you
2022.
saying?
From supplementary cause list, serial number.
Let me just deliver the judgment.
Okay.
This revision is dismissed. Yes, which item?
From supplementary cause list, serial number 16.
16.
16.
16.
16.
You are the advocate on record?
No, with the instruction of the advocate on record,
Who is the advocate?
Mr. Sadab Iqbal,
Okay.
may I permit to withdraw that
चलिए
matter?
withdraw का order कर दीजिए.
The petitioner has been amended.
साइन कर दीजिएगा अपीयरेंस दीजिए.
From supplementary list for orders item 1, criminal region 365 of 2019.
ये डिफेक्ट में है ये भी. Orders में किस लिए? ये orders में क्या चीज़ के लिए? हाँ, judicial orders. Next week under the heading for orders. Who is for the petitioner? What is the stage of this case?
We are carrying the cause in charge.
Yes. What is the stage of this case? आपको कंप्यूटर में नहीं पता चलता है? और तो पता करिए, पता करके बताइए. इंफ्रैक्चुअस केसेस को हम लोग पेंडिंग नहीं रखेंगे ना. Come by 1 o'clock.
For case filing item 2, WPS 2780 of 2023.
The date of birth of the petitioner's mother was 1/6/1954. She has worked and now she has retired, superannuated on 31/5/2014, earning salary, wages for the entire period.
2018.
14.
14.
Okay, superannuated on this date.
Yes, that is there here. So once she has worked and retired,
Note that
during
date. No, I note on that. The date of retirement which is page 25 is 30/4/2011. So just only correction that.
Yes, so what are you claiming?
No, I verified. This is scheme 2018-15 itself has been declared ultra virus, not LPA 350. Now, my submission was that I have applied in the year 1999. At that time, that the scheme was in force, and even it was declared ultra virus also.
That scheme under the voluntary scheme.
Yes, that was under the voluntary scheme, and my application was recommended by the respondent approved. So,
You come to
whether,
page number 37.
No, sir.
37.
37. No, sir.
The second paragraph. Under such circumstances, the petitioner withdrew the application filed under female voluntary retirement scheme. Correct?
yes, and this is also in the pleadings.
Yes. So you
Pleadings is
withdrew it
also
also.
there.
You forget about it whether right crystallized or it did not crystallize.
Kindly see paragraph 6, page 8 also, pleadings are there.
It was their submission, I think.
No. It was not their submission. I have.
Petitioner was appointed. The brief fact of this case, the
कौन सा पेज नंबर बताएं मिस्टर?
Page, paragraph 6, page, come to page 7, 8, sorry, page 8. Top में 3 lines. Under such circumstances, the petitioner withdrew
Yes. It is in
the
your pleading
application
also.
filed under female voluntary retirement scheme.
Bullet, I admit, she has bullet admittedly taken all the benefit. So bullet, so only contention bullet with the 99 and more when if she has withdrawn, there is no case.
देखिए, WPS number 2780 of 2023. Counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has opposed the prayer of the petitioner and has submitted that the petitioner is not entitled for any relief under the female voluntary retirement scheme on account of 2 reasons. Firstly, she worked for the entire period of her service and attained the age of superannuation, and further, and it has also been mentioned in paragraph
Paragraph 6, page 8.
6 of the writ petition at page number 8 that the petitioner had withdrawn her application filed under the female voluntary retirement scheme.
And this scheme itself has been held to be.
And the learned counsel has also submitted that the said scheme has also been held to be ultra vires as declared by this court in the judgment passed in FIR Hoover.
फिर
Fir Hoover versus Coal India Limited, reported in 2018, SSC Online, JHAR 1511. It is counsel for the petitioner.
We have also submitted that she has worked till her age of superannuation.
Forget it. That
Yes.
But only thing that paragraph 6 may read bullet. I have not withdrawn bullet because that is misnomer, that will be incorrect bullet. Page 7 bullet. When she applied for female voluntary retirement scheme in order to provide employment to her son, the respondent management all of a sudden raised a dispute and wrongly recorded her date of birth as 1/6/1944 in National Electronic Information in order to deny the benefit of the female voluntary retirement to the petitioner, which is the female employee under the age of 50. Under the circumstances, the petitioner withdraw the application filed under the female voluntary scheme. Thereafter, the petitioner represented before the management to correct the date of birth and alternately, so not get her examined by the medical board to confirm her date. So, the case is that ultimately why she withdrawn, because there was an age dispute. Ultimately she won because she was declared they have considered 44 and it was declared 54. So that was the circumstances I only wanted to say.
The learned counsel for the petitioner has submitted that in response, the learned counsel for the petitioner has submitted that the withdrawal of the application under female voluntary retirement scheme was on account of the reason that there was a dispute with regard to date of birth was raised. But it is not in, but during the course of argument, the learned counsel does not deny that the mother of the petitioner attained the age of superannuation while in service. And thereafter she never applied afresh for female voluntary retirement scheme. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, as recorded in the earlier orders passed by this court, in writ petition being WPS number 4643 of 2009, as well as in LPA number 896 of 2019, that the petitioner had applied under the aforesaid voluntary retirement scheme and had withdrawn the same. This fact is has also been mentioned in the writ petition. However, the petitioner is trying to explain the circumstances under which it was withdrawn. This court is of the view that the state scheme having been withdrawn and also been declared ultra vires by this court, the petitioner is not entitled for any benefit under the same state scheme.
You know, this 99
Accordingly, this court is not inclined to grant the relief as prayed for by the petitioner in this writ petition, which is hereby dismissed. एक इनका respondent का submission लिखाइएगा. The age or the date of birth of the petitioner was 1/6/1954. She attained the age of superannuation on 31/5/2014.
This scheme 99 has never been declared ultra vires. The
Need
18
not.
has been.
बात तो छोड़ दीजिए. आप
वो
उसमें
that is,
क्या देखना?
many people have been appointed under 99 scheme.
It does not nullify the appointments. It only
That's
declares
another
it
thing. So
ultra
I'm
vires.
not saying for myself.
you were not
because
right.
99 scheme was not declared ultra vires. 18,
Infractuous
16
थोड़ा सा एनर्जी दूसरा केस के
जी जी हमने इस पर तो हम खुद ही कह रहे हैं कि ऐसा हुआ है.
ठीक है.
Item 3 is 2825 of 2023.
Yes. पता किए आप है ना कैट का जुरिस्डिक्शन 8 भी क्या पिछले आए थे. अगर मान लीजिए कोई जुरिस्डिक्शन इशू काउंसिल नहीं रेस करेंगे तो ऑर्डर हो गया, लेकिन जुरिस्डिक्शनल इशू रहेगा तो हम तो नहीं करेंगे. इसके लिए फिर आपको WPS number 2825 of 2023 on the when the matter was taken up on 23/2024, an issue was raised regarding the maintainability of the present writ petition. As the petitioner was working as the petitioner claims that her husband was working as Khalasi in South Eastern Railways, Tatanagar. However, the matter was adjourned for the petitioner to seek instructions. The learned counsel for the petitioner seeks permission to withdraw this writ petition. He submits that liberty be reserved with the petitioner to move Central Administrative Tribunal. The learned counsel for the respondents has no objection to the prayer made. Accordingly, this writ petition
कंडोनेशन कर दीजिए. 83 ईयर में डेथ की है, कभी मिलेगा भी नहीं मालूम.
हाई कोर्ट के ऑर्डर से एक रीजन ऑर्डर पास किए है ना, तो बस जब हाई कोर्ट में 226 में ऑर्डर हो रहा था तब क्यों नहीं बोले कि पिछला सदी में ये रिटायर किए? उस वक्त तो नहीं बोले आप. तो बस फ्रेश कॉज ऑफ एक्शन हो गया इनके लिए. रिटायरमेंट बेनिफिट्स, पेंशन, ये सब का कोई टाइम बार्ड नहीं होता है, राइट. और उनके पास डॉक्यूमेंट है नहीं है, वो अपना ट्रिब्यूनल देखेगा क्या डॉक्यूमेंट है क्या नहीं. Accordingly, this court is not inclined to entertain the present writ petition. However, this writ petition is disposed of with an observation that the petitioner may avail the remedy before the Central Administrative Tribunal within a period of 1 month from today. टेंशन को लेके इतना नहीं आपको सेंसिटिव होना है.
Item 4, WPS 4871 of 2023.
Who is there for the petitioner? The petitioner का जरा वो देखिए एडमिट कार्ड एनेक्शन 2. Her paper is English, right? इन्होंने जो चार्ट दिया है यहाँ पर, एक दिया है कि दूसरे कम मार्क्स वालों का अपॉइंटमेंट हो गया है. पेज नंबर 19.
But no, that is on the basis of district wise merit list.
नहीं, you just see इसमें एक भी इंग्लिश का कैंडिडेट नहीं।
हाँ
देखिए चेक करिए।
जी जी
जब इंग्लिश का कैंडिडेट ही नहीं है, their case cannot be compared with
compared
these.
with those
Is that
candidates.
correct?
हाँ but no, that is correct. Your lordship's observation is absolutely correct.
This could, nobody appears on behalf of the petitioner. Yesterday also, the petitioner was absent. The learned counsel for the respondents has opposed the prayer of the petitioner and has submitted that the present proceedings arises out of advertisement number 21 of 2016, and in view of the judgment passed by the Honorable Supreme Court in
Civil appeal number. Page
civil
number
appeal
3
number
at top.
civil appeal number
403. At page
4038 of कहाँ लिखे हैं?
पेज नंबर 3 पे जाएगा
3 पे
हाँ at top.
At top, yes. Civil appeal number 4038 of 2022 and contempt petition civil number 612 of 2022 arising out of the same selection process, and in view of the order passed by this court in WPS number 6224 of 2023, the petitioner is no relief can be granted to the petitioner in this writ petition. He has also submitted that considering the fact of this case, the petitioner had applied under the subject English as mentioned in Annexure 2 to the writ petition, and the petitioner is trying to compare herself by referring to the chart at page number at paragraph number 13 with regard to students, with regard to candidates under different subjects altogether, and none of the subject mentioned in paragraph 13 refers to the subject English, right?
But
He submits that otherwise also the petitioner is not entitled to relief as prayed for. Since the petitioner is absent, yes, considering the aforesaid facts and circumstances of this case, and after going through the records and also the judgment passed by this court in WPS number 6224 of 2023, decided on 28 February 2024, coupled with the fact that the petitioner is trying to compare his case, his and her, compare her case with candidates of other subjects as mentioned in page number 9, in para number 13 of the writ petition. This court is not inclined to grant the relief as prayed for by the petitioner in this writ petition, which is accordingly dismissed.
Item 5, WPS 4875 of 2023.
Family pension for the second wife. As per the customary law.
You have taken instructions yesterday, you want an order on merit. Listen to the order. Yes, respondent, what do you have to say?
But for
We can declare her rights under this writ to
there is
restriction.
no declaration as it has not been mentioned in the writ petition lot that there is a declaration has been made in favor of the
We have mentioned it
petitioner.
in the assembly election, and the husband of the petitioner also is mentioned is assembly election. He said, I have a two wife. Name is mentioned in the assembly election कि I have a two wife. उन्होंने mention किया अपने form में कि मेरे as per the customary I have two wife. That is we are claiming कि first wife and as per the accountant general is asking for you ask for no objection to your second wife. Then I provide family pension. See, giving no objection कि मेरे को ये नहीं है. Otherwise, we are not. ये compromise में ये था कि she giving a half to the both person.
Compromise कर लिए.
No, this is not a compromise. She is giving a no objection certificate to the first wife. We having no objection to get this family pension. We are both on the understanding कि हम लोग half कर लेंगे. But she is denying कि मुझे नहीं है. You are not legal wife. After getting a pension, she is denying कि हम नहीं देंगे. That's the reason coming to that कि as per the mention in the assembly form leadership, he mentioned कि I have two wives.
Where is a letter of the accountant general to give you 50%?
No, this is not a letter to accountant. He is asking for no objection.
Where have you stated he is asking for no objection? Do not speak anything which is out of the records. Please don't.
We are not in. But is first wife is claiming कि I have been entitled for the family pension. The accountant general has stated.
Where is it? Where have
we
you
have not annexed this, but this is
no,
not.
We do not know. If you have things which you have not annexed, please don't speak. Right? WPS number 4875 of 2023. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner has raised a point before this court the learned counsel for the petitioner submits that the husband of the petitioner, while filing his nomination for election, had declared that he had two wives and the present petitioner was his second wife. She submits that on the basis of such declaration, the petitioner is entitled for family pension. The learned counsel has also submitted that as per the customary law, as per the Santhal customary law, there is specific custom of keeping two wives, and therefore the petitioner, being the second wife, is also entitled for share in the family pension along with respondent number 7, who is the first wife. In support of her argument, the petitioner has referred to Annexure 8 to the writ petition.
Annexure 4 is the notary certificate. So we are giving to the Annexure 4 leadership. Kindly see the Annexure 4 leadership. We are giving to consent to the first wife. We have no objection to get the family pension.
Annexure?
Annexure 4. This is an agreement. Notary certificate.
It is the agreement
Yes,
between the first and the second wife.
the learned counsel has referred to the agreement as contained in Annexure 4 entered into between the first and second wife to submit that after the death of Dr. Anil Murmu, the husband of husband of petition number 1 and 7, who was MLA and died on 17/1/2017, wherein the petitioner and respondent number 7 agreed that the first wife will be entitled to receive pension every month, and she will give 50% of the said pension to the present petitioner. She submits that after receiving the entire amount, now respondent number 7 is not giving 50% of the pension, and therefore the present writ petition has been filed. Okay. The learned counsel has also relied upon annexure eight to the writ petition and the corresponding document, the corresponding statement in paragraph number 17 to submit that as per chapter number 17 of the book written by W.G. Archer, second marriage is permissible as per Santhal tribal laws. The learned counsel for the respondents have opposed the prayer and has submitted that the petitioner is not entitled for the relief as prayed for. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the rights of the petitioner arising out of Santhal customary law, if any, cannot be decided under writ jurisdiction. Moreover, the status of the petitioner as to whether the petitioner is governed by Santhal customary rights also cannot be decided in writ jurisdiction. The status of second wife and the rights and the rights of the second wife if any, flowing out of any customary law and its impact and its interpretation and applicability vis-a-vis the other governing laws of the land also cannot be decided in this writ jurisdiction without any foundational basis. This court is of the considered view that merely because the ex-MLA had given any declaration regarding his two wives, the same does not confer any legal right upon the petitioner.
And it should be also said that
This court is also of the considered view that any private arrangement between the petitioner and respondent number 7 cannot be enforced through this writ jurisdiction. Considering the totality of facts and circumstances, this court is of the view that the relief as sought for cannot be granted by this. This court is not inclined to grant the relief as prayed for by the petitioner in this writ petition, which is accordingly dismissed.
May I one in Annexure 3 is also Anchal Adhikari Bhutikal Parivarik Sadasya Suchi is
The learned counsel has also referred to the family tree issued by the circle officer. This court is of the considered view that the family certificate issued by the circle officer also does not confer any legal right upon the petitioner.
Item 6, WPS 4897 of 2023.
In this writ petition, the petitioner has prayed for quashing of dismissal order and for reinstatement of your petition. May I be permitted to bring some important dates before your petition? Your petition, the petitioner was appointed on 25/6/2007 as Anganwadi Sahika. Your petition on 5/12/22, all of a sudden she received a dismissal order from respondent number 4 without issuing a notice or without any inquiry, the dismissal order was issued. Subsequently, the petitioner approached this writ court by referring WPS number 6718 of 22, which was heard on 3/4/23, my lords, wherein that dismissal order passed by respondent number 4 was quashed, and the petitioner was directed to furnish a copy of that order. Subsequently, the respondent were directed to issue notice to the petitioner so as to she can put her side of it. She furnished a copy of the order on 19/5/23, but subsequently no notice was again served to her, and a dismissal order was again passed by respondent number 2 on 28/6/23, your ladyship. In that dismissal order, your ladyship, it has been stated that as an internal inquiry was conducted by the respondents, but that inquiry report was neither furnished to the petitioner, your ladyship, and also it has been stated that a complaint was received by them from the villagers. But again, a copy of that complaint has also not been served to the petitioner, your ladyship. I have stated the same in paragraph number 12 and 13 of my petition, your ladyship. It was directed to them to issue notice so that I could present my side. At least I may be given a chance to be heard, my lordship. But again, no such notice was issued. I was not even called to the office, and again a dismissal order has been passed against me, your lordship.
You were not present when this proceeding was going on.
No, your lordship.
Kindly read the order and show and tell us that you were not present. We will book them.
No, your lordship. The order talks about all the things that happened before the previous writ petition was preferred, your lordship. After that writ petition, subsequently the order has not talked about any notice that was issued to me to be present before them, your lordship. The order on page number 23, third paragraph, 28-22.
You read it from first paragraph.
प्रस्तुत बात आवेदिका कोयलमुनि धानपुर सेविका एवं संतना देवीपुर सहायिका सोनमर 1 ने माननीय उच्च न्यायालय के द्वारा वाद WPS नंबर 6659 एवं WPS नंबर 6718/22 बनाम राज्य सरकार एवं अन्य के पारित आदेशानुसार वाद पर अग्रतर कार्रवाई सुनवाई हेतु आवेदन का आलोक में किया गया है। अभय
Yes, correct or
yes,
wrong?
This is correct.
Next paragraph.
अभय पक्षों द्वारा न्यायालय में उपस्थिति दी गई एवं उनके आवेदकों को लिखित कथन मान लिया जाए पर आधार पर आवेदक पारित कर आदेश पारित करने का निर्णय लिया गया।
लिखित आवेदन दिया गया, right? You appeared. उसके next paragraph.
आवेदिका द्वारा अपने आवेदन में माध्यम से प्रतिनिधित किया है कि उनके द्वारा जो भी भूल चूक हो गई हो उसे माफ किया जाए एवं पुनः कार्य करने का मौका दिया जाए। भविष्य में आंगनवाड़ी केंद्र का
Yes, correct or wrong? So फिर आप how do you say?
Your lordship, that is the representation that I made.
That's right. देखिए.
Your lordship, I have worked for 16 long years and
Very
on
good.
first instance, my lordship, in the 16
WPS
long
number
years,
4897 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was working as Anganwadi Sahika since 25/6/2007 and was dismissed by order dated 5/12/2022. And her services was dispensed by order dated 5/12/2022 without giving any notice, and consequently when the same was challenged in WPS number 6718 of 2022, an order dated 3rd April 2023 was passed, and this court had set aside the order on ground of violation of principles of natural justice, and the matter was remitted to the concerned authority to take fresh decision after giving a notice to the writ petitioner. The learned counsel submits that thereafter the impugned order has been passed and no fresh notice as such has been issued to the petitioner.
yes, sir.
after the learned,
Neither the complaint of the villagers also been furnished.
even the complaint of the even a copy of the complaint of the villagers was not given to the petitioner. Your any statement made in the writ petition?
Paragraph 13, your edition.
The learned counsel has referred to paragraph 13 of the writ petition to submit that in the impugned order dated 28/6/2023, a complaint letter of the villagers dated 4/8/2022 has been mentioned, but the complaint-wide letter dated 4/8/2022 was again not furnished to the petitioner with all mala fide intention. After hearing the, are you opposing?
Your Ladyship, the impugned order has been clearly stated that I'm reading from one before the last paragraph, Your Ladyship. कोयलमणि धान एवं सहायिका संताना देवी को बार बार चेतावनी देने के बाद भी उनके केंद्र संचालन के संबंध में कोई सुधार नहीं आने के कारण ग्रामीण के द्वारा शिकायत पत्र देना एवं 77 से अधिक लोगों के द्वारा चयन।
The learned counsel for the respondents has opposed the prayer and has submitted that impugned order has been passed pursuant to the order passed by this court, and a meeting of the members of Gram Sabha was also called, and in their presence and they had and thereafter the impugned order, which is a well-reasoned order, has been passed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that earlier the services of the petitioner was dispensed by the order dated 5/12/2022, which was set aside by this court in WPS number 6718 of 2022, by the order dated 3rd April 2023, on the ground of violation of principles of natural justice, and thereafter, and with an observation, and the matter was remitted to the respondents. Thereafter, the impugned order dated 28/6/2023 has been passed. Upon perusal of the impugned order itself, it is apparent that the impugned order has been passed as a sequel and in compliance of the order passed by this court earlier in WPS number 6659.
That was with respect to different petitions.
Yes, in connection with WPS number 6718 of 2022. The impugned order reflects that appropriate written submissions were also filed by the petitioner, and the petitioner had also submitted that the errors which have been committed would not be repeated. It further records that there was gross irregularity in the matter of running the Anganwadi, and the petitioner was not attending the Anganwadi regularly. It further appears that the impugned order has also referred to the proceedings which had taken place in presence of the villagers on 28/2022.
That Gram Sabha was conducted before the previous writ petition litigation.
So that Gram Sabha was not nullified, isn't it?
Yes, Lordship, but after that only.
Please don't disturb. And
The Lordship, in the third paragraph, I believe it's written, जांच दिनांक 17/8/2023.
yes, and thereafter a fresh the impugned order also reflects that a fresh inquiry was conducted and a report was submitted by letter dated 17/8/2023, wherein it was found that in spite of repeated opportunity to ensure that the center is run properly, the petitioner did not mend her ways. It has also been mentioned in the impugned order that at the time of sudden inspection of the Anganwadi, the petitioner was found absent, and in response she had stated that she had gone to attend the additional charge of another Anganwadi, namely Era Hattu, and it has been, but on that day the new on that day Anganwadi Sevika Era Hattu had already joined, and therefore there was no question of the petitioner to go to Eran Hattu for discharge of any additional duty. After going through the impugned order and considering the aforesaid facts and circumstances, this court is not inclined to quash the impugned order, and accordingly there is no merit in this petition.
For admission, item 7, criminal law 305 of 2019.
Time may be allow, my lord, instruction, my lord. Compromise का चल रहा है. Status of the case will पता कर लेते हैं. First time चढ़ा है.
आप अपना केस बहस करें.
इंस्ट्रक्शन ले लेते हैं ट्रेनिंग में. Compromise का चल रहा था. Husband and wife.
Compromise का तो कोई बात ही नहीं है.
Restoration वहाँ गवाही होने वाला था. 7/6/7 को डेट पड़ा है 24.
आप जरा अपना आईए में देखिए, आपका जो फर्दर जो है ना, adjournment on the pendency of this case has been rejected, right? As back as in the year 2019. उसके बाद तो कोई स्टे नहीं हुआ यहाँ से आईए में, तो फिर there is no question that the matter would have remained at this stage. अभी तो एविडेंस सब हो गया, आपको नहीं पता?
केस पेंडिंग हो रहा है एज पर द स्टेटस.
क्या स्टेज है केस का?
ये तो क्योंकि ये भी दिखा रहे हैं कि 6/7/2024 को केस नेक्स्ट डेट है. तो मैटर इसमें नोटिस हुआ था और अदर साइड से कोई अपीयर कर रहे हैं ऑन बिहाफ ऑफ द नॉट द विक्टिम.
आप स्टेट है ना, आपका कोई रोल नहीं है. एफआईआर है ना, एफआईआर से आप अपने वहाँ पर जो आईओ हैं या जो भी होंगे आप कोर्ट से पूछ के बताइए, आपका कोई कम्युनिकेशन नहीं है कोर्ट से?
नहीं, जो स्टेटस दिखाता है उसमें हम लोग चेक किए हैं।
क्या विटनेस एग्जामिनेशन दिखा रहा है, क्या दिखा रहा है?
नहीं, अभी तो उसमें डेट के लिए अगला डेट का दिखा रहा है।
नहीं तो डेट से नहीं ना, आप अपने ऑफिसर से पूछ के बताइए क्या स्टेज चेंज हो गया होगा तो क्या इसमें डिसाइड कर?
नहीं, ऐसे तो इसमें कुछ मैटर रहा नहीं गया, इसलिए क्योंकि ये डिस्चार्ज पिटीशन फाइल किए थे, दैट वाज रिजेक्टेड बाय द लर्नेड ट्रायल कोर्ट।
क्या ग्राउंड है? आप अपना ग्राउंड बताइए, अब छोड़िए सब बात।
इंस्ट्रक्शन ले लेते हैं अगर
क्या इंस्ट्रक्शन लेना है इसमें?
कि पेंडिंग है कि डिस्पोजल हो गया है।
क्या होगा अगर मान लीजिए अगर हमको अलाउ करना होगा तो हम पता करेंगे कि पेंडिंग है कि डिस्पोजल होगा, डिसमिस करना होगा तो क्या फर्क पड़ेगा?
एक मौका तो दिया जाए, देख लेते हैं, क्लाइंट का इंस्ट्रक्शन ले लेते हैं।
ठीक। Criminal Revision 305 of 2019. Counsel for the petitioner submits that the counsel for the petitioner seeks adjournment and to find out the present status of the case. The records reveal that there is no stay granted by this court. One IA number 6756 of 2019 for stay was filed, enclosing therewith a copy of the order passed by the learned court, refusing to grant any further adjournment on the ground of pendency of this case. And the date was fixed as 22/7/2019 for framing the charge. Since the petitioner is seeking adjournment, post this case on 2nd of April under the heading for final disposal.
Item 8, Criminal Revision 309 of 2019.
आप भी पता करिएगा. The learned counsel for the state is also directed to intimate this court regarding the present status of the case on the next date of hearing. Yes, petitioner. Who is for the petitioner? क्या heading में है ये?
Admission तो कौशिक सर शामिल हैं।
मिस्टर कौशिक सार्किल को बुलाइए, तो रोज कोर्ट आते हैं। पास होगा मानो।
Item 9, Criminal Revision 311 of 2019.
Your Worship, this is against the acquittal for the offence under section 341, 323, 500.
Is it maintainable?
Yes, Your Worship.
Is it maintainable?
This is petty offence.
Sorry?
I haven't idea.
Is it maintainable?
This is maintainable, yes.
How do you see it?
Yes, this is maintainable.
Revision against acquittal?
Yes, sir.
You examine the
High Court rules.
Yes, High Court rules and the judgments also. There is Tuklal Yadav, then Joseph Stephens, judgment of the Supreme Court. Right? एक केस हम लोग रखे हैं ना मेंटेनेंस के लिए। हाँ, नहीं वो नहीं, एक कल मिस्टर कृपा शंकर नंदा का मैटर था, उसमें डेट कौन सा था?
18 का डेट है। 18 का डेट।
18 का डेट है, उसी दिन रख लेते हैं इसको।
हाँ, वेरीफाई करके हम बता देंगे।
18 का डेट है ना?
18।
हाँ, learned counsel for the parties are present. The present petition has been filed by the informant and also the victim.
Yes, his informant is the victim.
Informant victim against the dismissal of appeal filed by the petitioner. The learned trial court had
Acquitted.
acquitted the
That acquitted that opposite.
हाँ, इसका तो अब और कुछ नहीं होगा इसका तो डिवीजन ही
There is
होगा.
only one point, Your Lordship. The NG report supports that case. The London Appellate Court has acquitted because they say that there was a counter case also which has not been placed by the informant before this honorable court, before the honorable court. That is the acquittal by the, so in that case, Your Lordship. But it's the duty of the accused person also to bring on record regarding the counter case. Because there was a case and counter case as per the this. So being the informant, he has not
Case
brought on
and counter case by itself is a ground for acquittal or there is other reason also for
No, there is other
इसमें नहीं
reasons
होगा
also.
इसमें तो appeal नहीं हो सकता है because the victim had filed the appeal
Yes.
and the appeal the acquittal order was passed by the trial court.
Yes.
The victim had filed the appeal
Yes.
and that appeal has also been dismissed. Now revision is the only remedy.
Yes, sir.
अब further तो appeal नहीं होगा.
No, further appeal is not maintained.
हाँ हाँ yes yes tell
In
me.
this, yes, sir.
Yes,
This should be
kindly,
an-
yes.
yes.
Let's have a look at it.
Yes. Now, as per the prosecution case, Your Lordship, although he has been acquitted for the offence under section 341, 323, 506, 34 by the trial court, which is being affirmed by the appellate court, Your Lordship. Now, the allegation as per the first information report, Your Lordship, the para 2, this is that these all these opposite party number 226, Your Lordship, they have attacked this informant on 5/9/2011 at about 1:45. They have beaten the informant with the butt of the pistol, in which the informant sustained the injury in the hands and the legs, and he got badly injured, Your Lordship. Now, if we just see the doctor medical report, Your Lordship, the medical report as in the trial court, Your Lordship, it's the page 27, Your Lordship. Page 27, para 7.
This is the injury report of the victim.
Yes, informant is the victim only.
Yes.
PW5 is the doctor, Your Lordship, who has examined the victim or the informant, PW5. This paragraph 7, Your Lordship,
Yeah.
page
Then what
27.
happened after
Yes.
that?
PW Dr. Shweta Tiwari, she
I've
said-
seen the.
Yes. So all these injuries reports are there. So all these injuries were caused by the heart and
Where
brain
is the
substance.
finding?
Finding of the learning court is as per the page 29.
Para 11. Para
Page-
11.
Para 11, page 29.
Para 10.
Para 10 it starts but pain is
Let us see para 10.
Yes. The above evidence shows that the informant and other witnesses have supported the case of the prosecution. But there are some important contradictions in their version. So the informant says that 50,000 was snatched by Manohar Ajam, the accused. He does not say anything about the wristwatch and the gold chain. PW2 Shamin Raja says that he was present at the place of occurrence and that the accused person took away money and the gold chain. He does not say anything about the wristwatch. Khadim Rasool says that money, wristwatch and gold chain was taken by the accused. While out of PW1, 2, 3, 4, each say that he was present at the occurrence. None of them say the other was present. The informant does not say any word about the presence of other witnesses at the scene. Each just come and says that he was present. There is no coherence in the story. All the witnesses are rated. No witness is added in the place of occurrence was examined by the prosecution. But the case becomes clear by the deposition of the IO of the case, who was examined as PW6. All the above mentioned witnesses have said that police came and saved the informant. It is the story of the informant throughout that one DB Singh or DB Sharma from Lower Bazaar police station was present at the meeting along with 4 constables. When they came out, the police moved ahead and behind them, the incident took place. The police returned and saved them. But the IO says that there was no DB Singh posted at Lower Bazaar police station at the time of the incident. The IO says that no prosecution witness had taken the name
That's
of any.
Learned counsel for the petition and the state are present. Issue notice to opposite party number 2 to 6. for which requisite under speed post as well as ordinary process be filed before this court by 4th of April. Post this case on 2nd of May, awaiting service report. Office is directed to call for the records of the concerned court. Okay, that's it.
Yes, sir. Okay, sir.
Incident becomes admitted once there is a counter case.
Wednesday, sir. Yes, sir.
The counter case is very risky.
Only the investigation has been
And snatching is one part.
Yes.
Assault is another part. There may not be any snatching, but assault is another part.
Item 10, Criminal Region 316 of 2019.
His wife is undergoing a surgery in the hospital. He has not
Who's
come.
wife?
Mr. SS Chaudhary. So he has not come to the court. Will it be a next date?
Where is the opposite party? What is the status of
Yes,
this
sir. It
case?
is going on the evidence. It is running on the evidence. That I have checked on the reports.
Then what relief can be granted?
The relief would be because I have just gone through a little bit, my lords. I am not aware of the facts completely. An application was filed under section 228 of the CrPC. Because, my lords, cognizance was taken under section 307 also. And we were of the view that a lesser punishment would be inflicted if this is under some other section. So we had filed an application for 228. If that is accepted, so trial will go before the magistrate.
Framing of charge by itself
Yes.
is not sufficient, right?
Yes.
The court can give lesser punishment also.
Yes.
If the basic ingredients are present, then conviction can be under other
two
section
things
also,
will happen.
provided the parties are aware regarding the ingredients.
Yes, ma'am. Two things will happen.
So what
Yes,
is
ma'am. That is
required
what I am
be
trying to say,
decided
my
at
lords.
this
It will be a technical thing, because if this petition is allowed, the trial exclusively will be handed over to the magistrate. It will not go to the sessions itself. So इसीलिए है इसमें.
कैसे अभी कैसे हम ट्रायल इधर से उधर कर
वो नहीं होगा.
एविडेंस चल रहा है ना आपका.
हाँ.
तो फिर आप ट्रायल
हमको तो factually बता रहे थे, but senior will argue. I am not on that. Since I am knowing, I am informing this court.
Counsel for the petitioner is present. The learned counsel submits that, as per the status report of e-courts, evidence is going on. Prosecution, defense.
That was not very clear.
Evidence is going on before the learned trial court. However, he submits that the arguing counsel has some personal difficulty today, and therefore the matter be posted on another date. Post this case for final disposal on 2nd of April.
Item 11, Criminal Region 375 of 2019.
Yes, petitioner. Who is for the petitioner? Nobody appears on behalf of the petitioner. Post this case on 18th of April 2024. आप अपना मेमो ऑफ अपीयरेंस दीजिए. ये मेंटेनेबल है.
तो नहीं है in view of the judgment of
The learned counsel for the respondents has submitted that state has submitted that the present revision application is not maintainable. 18 तारीख को रख रहे हैं, उस दिन कुछ मैटर्स रखे हैं. उनका नाम आप अपने मेमो ऑफ अपीयरेंस से दीजिए.
Article 12 Criminal Legend 380 of 2019.
For this matter to the Anganwadi and party they compromise the matter. And they have told their
Where is the terms of settlement?
That also report is there.
The report is there. So do you withdraw this case?
By term of the
No, we can't say anything because there is no joint compromise petition filed over here. You say that it has been settled, you withdraw it. Terms of settlement में ये arrears of maintenance का क्या है नहीं है, we do not know.
So that has been written also.
No, it has not been written.
Can you see the report?
I've seen. आपको लग रहा है बिना पढ़े बताएं. You withdraw it. भाई अगर settlement हो गया है, you simply say withdraw
Party
it.
have settled their dispute.
You
Party
withdraw
have
it.
taken a divorce. And
They
they
have
have also
taken.
paid the permanent.
Fair enough. Then you have no threat from the opposite party.
You did that on the basis, Kali did that on the basis of the compromise.
No, because you see there is a quantum of permanent alimony, but we do not know whether the arrears of maintenance.
See, all the dispute has been resolved. That my submission.
That is the terms of the 13B application is not there before us.
Today I have a talk to the council.
You withdraw it then.
All that in the term of the compromise. That can be.
No, I will simply say dismissed as withdrawn. I will not say anything.
They dispute for me.
Criminal revision number 380 of 2019, the learned counsel for the petitioner submits that the dispute between the parties has been resolved and the matter has been dissolved and the matter has been resolved and the marriage has been dissolved on mutual consent under section 13B of the Hindu Marriage Act, and therefore he does not want to press this writ petition. Accordingly, this petition is dismissed as not pressed. चलिए साइन करेंगे.
Item 13 Criminal Legend 385 of 2019.
Who is for the petitioner?
I am appearing on behalf of the respondents.
OP?
Yes.
Private party?
Yes.
Is it maintainable?
Maintainable तो नहीं है, appeal होगा by 372 provision.
Two courts.
Petitioner is absent. The counsel for the petitioner is absent. The learned counsel for the opposite parties have submitted that the present revision is not maintainable. Pose this case on 18th of April. कुछ और भी matters रखें.
ठीक. My lord trial में appeal हुए थे, फिर appeal में भी upheld हो गया.
Trial में acquittal था.
और appeal में acquittal था.
अपील में
अपील में भी acquittal हो गया, मतलब upheld हो गया.
अपीलेंट कौन था? विक्टिम.
Victim. जोसेफ स्टीफन केस के हिसाब से
नहीं
अपील ही हुई.
ट्रायल में अगर मान लीजिए एक्यूटल हो जाता है, ठीक है, और विक्टिम उसमें अपील फाइल करता है अंडर 372. विक्टिम फाइल करेगा ना 372 में अपील, तो अपना एपेलेट कोर्ट में फाइल कर लिया. नाउ वो अपहोल्ड हो गया ऑर्डर ऑफ एक्यूटल, तो उसके अगेंस्ट में आप कौन सा अपील होगा?
जोसेफ स्टीफन केस 2022
जोसेफ उसमें उसका कन्विक्शन था और एपेलेट कोर्ट ने एक्यूटल पास किया था. It is not a case where the appellate court has passed the judgment of acquittal. The trial court had acquitted.
ठीक है देख लेते हैं जजमेंट.
नहीं, आप इसको कहाँ है petitioner इसके? Where is the order of acquittal passed by the trial court? इन्होंने लगाया है. Appeal has no merit. थ्री 372 में आपने अपील ऑलरेडी अवेल कर लिया है, दोबारा अपील थोड़ी होगा 372 में, मतलब पिटिशनर. इसको 18th को मत रखिए, 18th को मत रखिए, इसको फिर से लिखिए. काउंसिल फॉर द पिटिशनर इज एब्सेंट. द petitioner is the complaint था.
Complaint.
The case arises out of a complaint case. The petitioner is the complainant victim.
Yes.
The impugned order has been passed arising out of the appellate order whereby the acquittal order passed by the trial court has been confirmed. The impugned order has been passed under section 372 of CrPC. लिखा ही हुआ है, ऑर्डर में ही लिखा हुआ है. Application under 372 CrPC, right? Counsel for the opposite party, number 2 to 4 are present. Counsel for the state is also present. They submit that there is no illegality or perversity in the impugned orders, and they do not call for any interference. Since the petitioner is absent, in order to give one more chance to the petitioner, pose this case on 4th of April.
Item 14, General Resolution 396 of 2019.
This is the revision against discharge, Lordship. It was long back heard on 17/1/2020.
There is no stay. The court must have proceeded.
Yes,
is there any stay?
No,
Then?
no stay. As per the e-court status, it is at the stage of evidence.
Then what do you want to do?
Although it power can be exercised at this stage.
No, I will just keep everything open to you, but not at this stage.
Yes.
You take all the points before the trial court.
But,
when the evidence is going on,
yes,
interference at this stage and any observation at this stage is not proper.
Prejudice to the trial.
Yes. भाई आप बहस करेंगे, हम reason order pass करेंगे. I am duty bound to do so.
But in this case, Lord, the case and counter case, Lordship.
So case and counter case, it means that the incident is admitted.
The incident is admitted, but
therefore, this has to be seen at the stage of trial.
Yes, yes. As you Lordship.
You want to withdraw?
One more opportunity may be given, Lordship.
No, for what? You know that
there is no.
You can argue your case. We are not insisting on any withdrawal, but we just indicated what are the possibilities.
A case diary was called on the.
Not required.
But because in this record only a FIR is there, Lordship, and on the perusal of a FIR, no case under 307 bed orders.
FIR is the complete encyclopedia.
No, for that injury report and case diary was called for. And in this informant it also had also appeared.
There is no stay in this case. That's why.
Grievous injury have been found. Then.
But there is
injury.
That family member has been killed in this case.
Therefore.
And
but still evidence is going on. You do not know what
Nature of
evidence is
injury
going
and
on,
the-
they are hostile or not. We do not know.
As the trial has been proceeded on that
Yes,
liberty withdrawal.
Criminal Division number 396 of 2019. The learned counsel for this petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the trial has proceeded before the learned court and the impugned order refusing to discharge has been passed as back as on 9/1/2019, and there is no stay in the present proceedings. The counsel submits that liberty be reserved with the petitioner to raise all he also submits that there is case and counter case, and the dispute is amongst the family members.
Among two parties with regard to the sale of land.
Is with regard to two parties arising out of sale of land. Yeah. The learned counsel submits that liberty be reserved with the petitioner to raise all points before the learned trial court, and at this stage it does not want to press this present petition. Is that okay? The learned counsel for the respondents opposite party has no serious objection to the prayer made. Considering the facts and circumstances of this case and the submissions made by the petitioner, this petition is dismissed as not pressed. However, the dismissal of this case will not prejudice the case of either parties before the learned trial court, and it will be open to the petitioner to raise all the points which have been raised in the present petition and any other point which may be available to the petitioner before the learned trial court in accordance with it. Let this order be communicated.
Sign
State.
Item 15, Criminal Division 403 of 2019.
Very small matter of division application is filed by setting aside the order dated 7/2/19 of it. Extend that the petition filed by the prosecution to recalling the PW5 as a witness is allowed, and the order is passed in connection with ST number so and so and arising out of PS case number so and so.
So, recall of witnesses, he must have been examined by now.
Humble prayer that only tendency to delay the
Yes.
such application has been filed.
Now much time has elapsed.
That is there, Lord.
Then
That is there.
what should be done? You want to press it still? It has become infructuous for all practical purposes.
इसी ground पर disposal करें.
Criminal Division number 403 of 2019. This petition has been filed for the following relief. The learned counsel submits that the learned counsel appearing on behalf of the respondents has submitted that the impugned order has been passed in connection with challenging the order of recall of prosecution witness. She submits that that there is no stay order in the present case, and the recall witness must have been examined before the learned trial court, and therefore for all practical purposes the present petition has become infructuous. Yeah.
हुजूर का फाइंडिंग हम
नहीं इनका सबमिशन After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the learned court has passed a recent order in connection with the recall of witness PW5. This court finds no illegality or perversity in the impugned order. Further, the fact remains that there was no stay order passed by this court, and the impugned order has been passed on 7/2/2019. Considering the totality of facts and circumstances, this court is not inclined to interfere with the impugned order. Accordingly, this revision is dismissed. Communicate.
Item 17, Criminal Provision 422 of 2019.
16.
16
Withdraw हो गया. आप अपना मेमो ऑफ अपीयरेंस दे दीजिए.
My name is appearing in the college.
ऐसे नहीं होता. उस वक्त आप थे नहीं जब, क्योंकि वो मेंशन करके किए थे. आप अपना दे दीजिए. Yes, petitioner.
Connection 10 is under challenge. Page number 71, it starts from page
Yes.
number 71.
What is the nature of order?
Offense under section 302. Application was filed under section 319 CrPC, Your Worship. The named accused, Pan Babu Ansari, he was named accused, Your Worship. And the witnesses, Your Lordship, that is witness number 10, 11, 12, 16 and 17, have specifically stated about this person, but in spite of the same, it has been rejected on the ground that initially one application was also filed by the prosecution also. That is at annexure 8, page number 63. That is 15/1/2018. Prosecution also filed one application under section 319. That was rejected by annexure 8 by an order dated 16/2/2018.
Where is it?
That is page number annexure 8, page number 63. May I read to you? That is
Just a moment.
Yes.
This was filed on 16/2/2018.
This was filed on 15/1/2018. 15/1/2018 को फाइल हुआ, and that has been rejected by order dated 16/2/2018. Prosecution has filed a petition under section 319 CrPC on 15/1/2018 prayer for arraigned Pan Babu Ansari as accused in this case for issuance of summon against it.
It was rejected. So
This
this
was
was not
rejected.
challenged.
Huh?
This was not challenged.
Prosecution इसको challenge नहीं किया. हुजूर कहिए एक इसका FIR देख लिया जाए.
नहीं FIR से नहीं.
FIR देख लिया जाए because इनका नाम है.
नाम है, सब कुछ है.
डंडा लेके ये आए.
FIR में फिर भी चार्जशीट तो नहीं हुआ.
चार्जशीट नहीं हुआ.
नहीं हुआ ना.
उसके बाद गवाही जब हुआ तो कैटेगरिकली
नहीं दिस पर्टिकुलर ऑर्डर.
हाँ.
अब इस ऑर्डर को चैलेंज तो हुआ नहीं है.
अब प्रोसिक्यूशन नहीं चैलेंज किया.
हाँ तो फिर आप
उसके
भी
बाद
तो चैलेंज
हम
कर
तो
सकते.
इन्फॉर्मेंट हैं हुजूर.
आप भी चैलेंज कर सकते थे because after all you are the informant of the case.
But
and you
also
are,
did not
you
challenge.
see, the informant does not have a locus as such, but informant is acting through the prosecution only, isn't it? The prosecution is representing the informant also before the court.
हुजूर इसमें खाली पेज 64 देखा है.
इस ऑर्डर को कैसे हम लोग बाईपास करें? What was the subsequent development after this? इसके बाद कोई witness examine हुआ? When was the fresh petition filed?
Fresh petition was filed on 30th of August 2018.
38
August 2018.
2018.
Yes.
What were the developments between this period? Nothing.
Simply page 64 देखा जाएगा. That is the previous
64.
situation.
This is not under challenge, no?
This is not under challenge.
Okay. पढ़िए.
Last में हम पढ़ देते हैं. Some fact has been stated before the court as PW8 and PW9. Further, PW10, PW11, PW12 have not supported the version of the informant. The deceased lady was 80 years old, sick lady, and was suffering from acute cardiac and lungs disease and several old ages disease. She died in normal course due to her illness. He further submitted that there is no strong and cogent evidence occurred against the person from the evidence laid before the court, and such power should be exercised and not in a casual and cavalier manner. As relied upon decision of such and such, appeal number 763 2017 dated under such circumstances, he prayed that the petition filed by the prosecution may be resolved. On the other hand, learned APP assisted by learned private lawyer engaged on behalf of the complainant clearly
आप जरा
submitted that
ऊपर
there
से
is
पढ़िए ना पेज नंबर 64 में. You are referring to the statement in the case diary.
after concluding the investigation.
No, no. On the other hand, the learned defense counsel.
On the other hand, the learned defense counsel has submitted that the witness examined in this case are highly interested witnesses, and they have deposed only to implicate Panbabu Ansari, who is only earning member of his family. Prior to death, IO has not sent up him for trial, which have been approved by Deputy Superintendent of Police and SP. It is further submitted that the statement of Kamal Mahato and Kailash Gildar has been recorded under section 161 CrPC in paragraph 63 and 64 of the case diary, where it has been stated that Panbabu Ansari was present at his working place, Dugda, which is far away from the place of occurrence. And same fact has been stated before the court as PW8 and PW9. Further, PW10, 11, 12 have not supported the version of the informant, which is totally an error of record. The deceased lady was 80 years old, sick lady, and was suffering from acute cardiac and lungs disease and several old diseases. She died in a normal course due to her illness. He further submitted that there is no strong and cogent evidence occurred against a person from the evidence laid before the court, and such power should be exercised and not in the casual and cavalier manners, as relied by him in the case of such and such, appeal number 763 2017 dated Etna. Under such circumstances, he prayed that the petition filed by the prosecution may be rejected. On the other hand, learned APP, assisted by learned private lawyer engaged on behalf of the complainant, clearly submitted that there is a sufficient material against the proposed arraigned accused, and he relied in the case of such and such, in which Honorable Court has pleased to lay down that CrPC section 319 summoning the petitioner as an additional accused under section 319 plea that the petitioner was discharged after accepting final report by the magistrate. Provision under section 319 is meant to achieve the objective that the real culprit should not get unpunished. A person who is named in FIR but against whom the police did not file charge sheet or drops the case can be proceeded against under section 319. For some of the prosecution witness clearly stated active participation of petitioner in commission of murder, and their deposition, if stand unrebutted, would be sufficient to convict the petitioner. No illegality in the impugned order. Hence, he prayed that summons may be issued to arraign accused person. In light of the submission, I go through the evidence of the witness examined on behalf of prosecution, from which it appears that PW1, 2, 3, 4, 5, 6, 7, 8, 9 have examined, but they have not supported the fact relating to involvement of the arraigned accused in the alleged crime. However, PW10, Imani Ansari, has adduced that arraigned accused along with other trial facing accused came at the courtyard of the informant and assaulted to the old deceased lady, Mariam Bibi. The evidence of PW11, Tabassum Bibi, and PW12, Samsuddin Ansari also supported the version of the informant. Further, the entire witnesses named in the charge sheet column have not been examined. Not much, only the doctor and IO of this case have also not been examined in this case. Considering the entire facts and guiding principle laid down by the Honorable Court, the court has to look into the matter very cautiously after examining the evidences of the entire witness named in the charges. Hence, petition for prosecution of arraigning the proposed accused is not to be considered at this stage and as such is hereby rejected. वो बोले कि at this stage को हम लोग नहीं consider कर रहे हैं and thereafter your lordship ये लोगों का गवाही हुआ. जो इसमें खाली आया जाएगा relevant page number 74. Page number 74 देखा जाएगा of the impugned order dated 26 February 2019.
What do you want to say?
ये लोग जो witnesses हैं
कहाँ है witnesses?
हम दिखा रहे हैं हुजूर.
Deposition दिखाइए.
हाँ deposition. हम position लगाएं. Page number 43 annexure 3. ईमानी अंसारी. पढ़ें?
देखिए
जी.
जब ये previous order हुआ था,
जी.
by that time 12 witnesses were examined, right?
उसके बाद और भी witnesses.
Witnesses है, उसके बाद वाले witnesses दिखाइए.
वो लोग मान लीजिए आईओ है और डॉक्टर है तो वो घटना के बारे में क्या बताएगा? वो तो बताएगा कि कैसे उनको चोट लगा. लेकिन जो मेन विटनेसेस है
Then under such circumstances, once a petition has been rejected under section 319,
वो बोला कि at this stage हम लोग रिजेक्ट कर रहे हैं.
तो इसीलिए ना
wrong
just a
and-
moment
and wrong.
at this stage reject कर रहे हैं and you say that the subsequent witnesses are meaningless.
नहीं,
तो बात खत्म हो गया.
नहीं मीनिंगलेस नहीं, वो तो गलत रिकॉर्ड कर रहा है ना. दैट इज एन एरर ऑफ रिकॉर्ड.
So
वो
you
बोलते
should
हैं
have
कि
challenged that order if the lower court has the trial court has conducted any error while rejecting the petition under section 319, then you have to challenge that
ऐसा ये
order.
होल्ड थोड़ी किया कि दिस पिटीशन वाज नॉट मेंटेनेबल, सब्सिक्वेंट पिटीशन वाज नॉट मेंटेनेबल, ऐसा होल्ड.
But on the basis of whatever evidence had come.
लेकिन वो दैट इज अ रॉन्ग रिकॉर्डिंग. वही तो पढ़ के सुनाए ना कि वो उसमें बोलते हैं कि पीडब्ल्यू 10, 11, 12 ये लोग जो एग्जामिन किया दे हैव नॉट सपोर्टेड द प्रोसिक्यूशन. दैट इज एन एरर ऑफ रिकॉर्ड. इसीलिए तो हम लोग
But that order is not under challenge.
ये लेकिन दैट
If
subsequent
court
order
has committed some error of record in an order which is not under challenge, how will I pronounce on that?
subsequent order में तो लिख रहे हैं कि हाँ ये लोग सपोर्ट किया है प्रोसिक्यूशन को जो अभी
But still
चैलेंज
that
में है.
petition has been rejected.
हाँ ये अनेक्शर जो हम चैलेंज किए हैं उसमें लिख रहा है कि ये लोग सपोर्ट किए हैं. हम इसलिए तो अनेक्शर 3 पढ़ा दे रहे हैं. वो आदमी आया उसके ऊपर में डायरेक्ट एलिगेशन है, एफआईआर में भी है. ये नहीं है कि
What is the reason for rejection in the impugned order? Impugned order has not been passed on the ground that the earlier order has been passed.
हाँ.
Impugned order has been passed after reappreciating the materials.
पेज नंबर 74 से हम पढ़ देते हैं.
74 से पढ़िए.
जी. यह घटना दिनांक 24/5/2015 के करीब 2:30 बजे दिन का घटित हुआ है तथा साक्षी संख्या 10 ईमानी अंसारी सूचक अपने साक्ष्य में बताया कि दिनांक 24/5/2015 को पान बाबू अंसारी डंडा से मारकर उसकी मां को जमीन पर गिरा दिया, जबकि सूचक की पत्नी तबस्सुम बीबी साक्षी नंबर 11 अपने साक्ष्य में बताया कि उसकी सास को माजुमा बीबी, पान बाबू अंसारी, परवेश अंसारी, अजीज अंसारी लाठी डंडा से मारे थे तथा परीक्षण में पारा 15 में बताया कि पान बाबू अंसारी दुग्धा में काम करता है, जिसके साक्षी संख्या 8 कैलाश बेलदार और साक्षी नंबर 9 कमल महतो के साक्ष्य का समर्थन होता है तथा साक्षी नंबर 12 शमसुद्दीन अंसारी, साक्षी नंबर 16 राजा
And what
बाबू
happened in
अंसारी.
the trial?
जी.
What happened to the trial?
ट्रायल के बारे में बताइए.
ये
आपको
हमको
ऐसा
अभी
नहीं लगता है 2019 के मैटर्स में सबसे पहला चीज आपको पता होना चाहिए ट्रायल में क्या हुआ?
इसको अर्जेंट कर दिया जहाँ पता कर रहा हूँ।
ना आप सीनियर हो गए हैं, 2019 का मैटर में ट्रायल का स्टेज नहीं बताइए।
ये अचानक चढ़ गया तो नहीं पता चल पाया, जिनसे कांटेक्ट में थे वो उनसे बात नहीं हो पा रहा है।
तो हम पूछेंगे तब बताएंगे
नहीं,
आप।
हम पता कर
उसमें आपको किसी क्लाइंट से नहीं पूछना है, आपको सिर्फ अपने ई कोर्ट में जाना है और जाके देखना है। इसमें किसी क्लाइंट के असिस्टेंस की ज़रूरत ही नहीं है आपको।
पता कर लेते हैं कन्विक्शन हो गया।
कन्विक्शन अगर हो भी जाएगा तो
तो भी
319 का
319 का
पिटिशन डज
application
नॉट
चलेगा।
बिकम
Does not
इन्फॉर्मेटिव।
become
Still the stage is important. नोटिस नहीं हुआ इसमें अभी तक?
नोटिस
17/20 को नोटिस
17/20
हुआ है।
OP2 is
Issue notice to
appearing.
respondent 17/1/2020 को
Where is up OP number 2?
OP2 is appearing also.
स्टेट तो हमको सपोर्ट करेगा क्योंकि इनका भी तो 319 का पिटीशन था।
But that has not been challenged.
ये तो आपको ना चैलेंज करना था, आप थोड़े हमको अथी कीजिए, अपोज कीजिएगा। आपका पिटीशन रिजेक्ट हुआ।
संजय कुमार
संजय कुमार
एंड संजीव कुमार सिंह,
इनका फोन नंबर भी पीछे लिखा।
हम लोग क्या
नहीं,
इनविटेशन
हम
कार्ड भेजें?
कर देंगे, हमको खाली फाइल दिया जाए।
फोन
हम-
नंबर नहीं है।
नहीं है।
Counsel for the petitioner is present. Nobody appears on behalf of the opposite party number 2. The learned counsel for the state is present. The learned counsel for the petitioner has submitted that there is consistent evidence on record regarding the involvement of the opposite party number 2. But this aspect of the matter has not been properly considered by the learned court. The learned counsel on behalf of the state the learned counsel for the petitioner has also submitted that earlier when application under section 319 was filed by the state, which was rejected by the order dated 16/2/2018, and by that time only 12 witnesses were examined, and the learned court refused to allow the petition under section 319 at that stage by observing that the matter is required to be looked into very cautiously after examination of the entire witnesses in the charge sheet.
And there is an error of record that PW 10, 11, 12 have
आपके
not
साथ बहुत प्रॉब्लम है।
हमारा
आप हमारे ऑर्डर को मत लिखिए। आपका केस का डिस्पोजल कर रहे हैं, नहीं कर रहे हैं ना?
जी जी।
बस हम प्राइवेट फेसी जो हमको लग रहा है कि हमको करना, आप उस एरर ऑफ रिकॉर्ड को हम रेक्टिफाई नहीं कर सकते।
जी।
ठीक है, ऐसे आप दिस यू हैव मेड योर हैबिट। आई एम नॉट डिस्पोजिंग ऑफ दिस केस। ना डिस्टर्ब करते हैं, आगे से ऐसे नहीं किया। आई एम जस्ट रिकॉर्डिंग इट फॉर माई मेमोरी। हम जब इसको देखेंगे ना तो हमको पूरा एकदम याद आ जाएगा कि व्हाट हैपेंड इन द कोर्ट प्रोसीडिंग्स। और किसी दूसरे कोर्ट में भी जाएगा तो उनको भी लगेगा कि दिस व्हाट ट्रांसपायर्ड इन कोर्ट प्रोसीडिंग्स। The learned counsel submits that therefore the subsequent petition in which the impugned order has been passed was maintainable, but the learned court below has not considered the evidences properly. बाकी evidence 17 तक लगा दिए हैं सब। the learned counsel submits that all the evidences laid before the learned court has been annexed along with this petition. नहीं लगाएं.
नहीं लगाया मुझे. Annexure 7 है व्यासुद्दीन अंसारी. वो डॉक्टर का आयु का नहीं लगाया.
आपको कुछ नहीं पता.
विटनेस नंबर 17.
आप ध्यान ही नहीं.
अच्छा वो है. वो तो आयु है. राजा बाबू अंसारी.
गयासुद्दीन अंसारी कौन है?
ये उनके रिलेटिव है.
तो
डंडा से मेरी दादी मारी है. उनका होता है जो डिसीज है सब.
आई विटनेस है ना वो?
आई विटनेस.
हाँ तो फिर आप बोलते हैं कि बाद में सिर्फ आयु और डॉक्टर एग्जामिन.
नहीं 17 भी.
तो फिर
जी जी
उसका तो एविडेंस आप लगाए ही नहीं है यहाँ पर.
17 का लगाए.
लगाए हैं?
पेज नंबर 60 एनेक्सर 7.
ठीक. In order to give one more chance to the opposite party number 2, pose this case on 18th April. 18th नहीं, 25th April.
25th.
Under the heading for final disposal.
Item 18
जजमेंट सब लेके आइएगा.
हाँ ले आएंगे 300.
Item 18 Criminal 425 of 2019.
Yes, petitioner. Is it maintainable?
Yes, mother, as because was acquitted by both the courts, mother, for the under section 138 in and trial
Both the
acquitted-
courts have
Yes, mother, trial court acquitted, mother, and confirmed by the appellate court, mother. Therefore, this revision. The acquitted, mother, the opposite party number 12, the acquitted on the ground, mother, in the check, the exhibit 4 and 4/1, mother, the seal and shield over this check, mother.
Yes.
But tomorrow the trial court must failed to consider the exhibit 5 and 5/1 manner when the return memo was issued by the.
Let us see the include orders.
Yes.
Trial court judgment.
The trial court judgment manner page 18, my lord.
Page 18. Give me the foundational dates.
Yes, my lord.
Date of check.
Yes. Date of check, my lord, the 16/6/2015, my lord.
16/6/2015.
15.
Bouncing. 21/7/15 presented. What is the date of bouncing?
17/2015.
This is second presentation.
This is the first one.
No.
First one.
On 21/7/2015, the check was deposited, but the same bounced due to insufficient fund.
Yes.
Complainant informed by the bank by return memo.
Return memo,
Right?
my lord.
Thereafter, complaint informed the accused, and accused told to deposit the check after
Yes.
15 to 20 days.
Yes, sir.
So it is
There was two checks was issued in Manu. One was taken back Manu by the OP number 2, and second was bounced.
on this complaint case is in connection with which check?
Check number Manu 001536.
17/8/2015 redeposited the check.
Yes.
Then it bounced insufficient fund. Yes. Then 18.
18/2015 legal notice was sent to Manu.
Yes.
Thereafter Manu's complaint was filed Manu.
But then what happened?
10/9/2015.
When was the complaint filed?
10/9/2015. That's the within time on that.
The check could have been presented second time.
No, first time Mano and first time dishonored, there was two check Mano. One check was the presented Mano and second check was the return back to the opposite party number to the with insurance.
Where are you
They
saying?
paid cash.
Where are you saying?
It is in complaint Mano.
Where is it?
Yes, Mano, it appears Mano in the judgment include also Mano. May I read Mano the paragraph 1?
You tell us that what is your ground. There are two forums where you have lost.
Yes, Mano.
You call out the legal ground.
Legal ground Mano, the learned both the courts Mano to fail to consider exhibit 5 and 5/1 Mano the written memo.
5 and 5/1.
5/1, which was written memo, which is written memo Mano under the seal and signature of the bank. That has not been considered Mano by the both the courts.
You are the complainant.
I am complainant.
Why? What is it in these two which has not been considered? What is the date of return?
Date of return memo Mano the 17/8/2015.
Both 5 and 5 17/8/2015.
15 Mano.
Where is the discussion about it?
Yes.
You read the findings. Para number 16.
17.
Para 16 also.
After hearing both sides, I perused the record. I find that in the present case, the defense of the plea is that he has taken only 1 lakh rupees, which they deposited in the account of complainant, but complainant did not return back the check. On the other hand, the complainant case is that the accused demanded 2 lakh rupees for his business purpose and issued to return the said amounts within 6 months. After passing 6 months, he issued 2 checks in rupees 1 lakh, out of which the check number 001536 and number of other is not remembered the complainant. The complainant deposited the said check in his account, which was dishonored on dated 21/7/2015. The complainant has produced 3 witnesses in support of his claim, and documentary evidence as Exhibit 1 is signature of advocate on the legal notice. Exhibit 2 is check number 131536. Exhibit 3 is the postal receipt. Exhibit 4 and 4/1. And 4/1 are the check deposit receipts, and 5 and 5/1 are written memo. Complainant has submitted that after dishonor of check due to insufficient fund on date 18/8/2015, he issued a legal notice. When I go through this legal notice, I find that the legal notice the complainant has stated that in month of December 2014, the accused demanded rupees 1 lakh from complainant for his personal work, and he assured the same will be returned within 6 months. After passing 6 months, on dated 16/6/2015, accused issued check number 15001536, which was deposited on dated 17/8/2015. The result of report, I find that firstly the complainant has not produced any documentary evidence as agreement regarding 2 lakh rupees. Secondly, in his legal notice, they has clearly stated that accused has demanded only 1 lakh rupees and issued only 1 check number 11001536 of rupees 1 lakh. But in complaint petition, this complaint has submitted that accused demanded 2 lakh rupees in entire complaint petition, and in his statement he did not tell the number of other check, which makes the claim of complainant doubtful. the perusal of record, I also find that the complainant has demanded through legal notice only 1 lakh rupees on dated 18/8/2015. In his complaint petition in para 9, he has submitted that on dated 18/8/2015, accused deposited 1 lakh rupees in his account. In his statement in para 29, when accused deposited 1 lakh rupees on same day, he was informed by bank. In para 30, in his account, the 1 lakh rupees was deposited on dated 18/10/2015. On same day, when he issued legal notice, in para 32, he deposed that he has filed this case only for check amount of rupees 1 lakh. In para 28, he has deposed that it is correct to say that accused deposited 1 lakh rupees in his account, which was accepted. It is pertinent to mention here that through legal notice, which was sent after dishonour of check bearing number such and such, the accused demanded 1 lakh rupees against the said check, and on the same day, accused deposited the 1 lakh rupees in complainant's account. It will be presumed that accused has deposited 1 lakh.
Who is for the informant?
Yes,
You are the accused?
yes, sir. I have been acquitted.
Where is the record? Record recording. क्या बोलना है आपको?
Usually, the legally enforceable debt, which are not proved by the, which has already affirmed by the trial court and subsequently by the appellate.
What was the legally enforceable debt?
That what amount, that is 1 lakh rupees or 2 lakh rupees, at this, that is pending, came in the
Check amount, check is there?
Yes, your Lordship.
There is a presumption. Was that your case that there was no enforceable debt?
That
No.
was, for that a case record will be called in, Your Lordship. All the exhibits may be called. Because I have not.
We just want to know that the appellate, this judicial magistrate first class, right,
Yes, sir. Yes, sir.
has passed an order by saying that the seal of the bank was not there in the check,
Check.
nor it was there in the deposit slip,
Yes, sir. Yes, sir.
right? But there is a return memo. Is that not sufficient?
5 and
Annexure
Exhibit
5 and 5(1) is a check return memo that can only be generated when the check is deposited.
This is the admitted fact that I had issued the check, Your Lordship.
You had issued the check is admitted.
Admitted.
The check return memo is also admitted.
Yes, Your Lordship.
So,
And subsequently, I had already deposited 1 lakh rupees in the
account of the
account of the informant, victim complainant, Your Lordship.
the check was for how much amount?
That was not ascertained. by the
Check
deposition.
amount was how much?
1 lakh rupees.
1 lakh rupees. You deposited that amount in the account of the
Complainant, victim.
complainant after bouncing of check.
Prior to same date, that is a finding received in the. in the
Same
order
day you
itself.
have deposited.
Yes, Your Lordship. This
So
is-
according to you, you had discharged the debt.
Yes, Your Lordship.
The second amount of rupees 2 lakhs was not, the second check was not produced.
This one came, I need to just verify the record, Your Lordship.
देखिए,
And
criminal revision number 425 of 2019. The learned counsel for the petitioner has submitted that the trial court had acquitted the accused in a proceeding under section 138 of Negotiable Instruments Act, against which the appeal filed under section 372 of CrPC was also dismissed. The learned counsel has submitted that the learned court, while the learned trial court, while acquitting the opposite party, has failed to appreciate Exhibit 5 and 5/1, which was the check return memo, and had taken note of the fact that the check did not bear any seal of the bank and that the deposit receipt also did not have any seal. The learned counsel submits that once there is a check return memo, there cannot be any doubt regarding deposit of the check. The learned counsel has also submitted that to this the counsel for the opposite party submits that the records of the case be called for. Office is directed to call for the records of the case from the concerned court. Let this order be communicated through fax. Post this case under the heading for final disposal on 25th of April.
Clear.
Appearance is zero. Item 19, criminal division 441 of 2019.
Ladyship, I am praying for adjournment.
Why do you need adjournment?
Your Lordship, it is to be argued by counsel Mr. Nilesh Kumar and he is not present in the court today.
When will he be present?
After holding the petition.
This is a case relating to discharge.
Yes.
What is the present stage of the case?
NBW has been issued and the case was pending for framing of charge.
Still pending for framing of charge?
Yes.
Since 2019?
Yes, Your Ladyship, we have filed an IA for amendment in the prayer portion in the main petition.
Amendment for what?
Amendment for setting aside the order dated 25/2023 whereby the bail of the petitioner has been cancelled.
We will not allow this. In one revision, 2 orders cannot be challenged.
Your Ladyship, that is why I am seeking for adjournment.
What is the next date in the case?
I am not aware presently.
You should be aware of everything when you are seeking adjournment. What is the next date in the case? 2019 matters, and Mr. Nilesh is quite well aware about the proceedings before the trial court. He must be conducting the proceeding before the trial court also. Am I correct? No instruction is required for this.
It may be kept after vacation. Mr. Nilesh Kumar will argue. Better to
Learned counsel. The learned counsel for the petitioner seeks adjournment. The driver of the truck.
He is the owner.
The owner of the truck is before this court, and in the petition filed before this court in para number 15, the petitioner has taken a plea that the seized articles exclusively belongs to the petitioner, which was purchased by him, and nobody else has claimed the articles. This court is of the view that essentially such statement is a matter of defense and cannot be considered at the stage of discharge. Right?
The entire case, if we see that earlier we have preferred the discharge application in revision. It was remitted back, and then again our order has been.
I am looking at your statement only.
Your Lordship,
It is one thing to say when the owner of the truck says that I have nothing to do with this article, right? My driver has done some crime, I am not concerned. That is not your case.
But your lordship, if any order may be passed, it may be.
Yes, I will. You see, I'm quoting your statement made in the petition. Quotation में डाल दीजिए पैरा नंबर 15.
Only there is that
Nothing.
if any order may be.
टाइम हम आपको टाइम दे रहे हैं आपको, लेकिन ये तो मेरे मेमोरी के लिए है, ठीक है? Since the petitioner is seeking adjournment, hold this case on 2nd of April under the heading for final disposal. चलिए.
Okay.
Item 20, Criminal 442 of 2019.
Criminal Revision 442 of 2019. The learned counsel for the petitioner. नाम बताएं. Sushant Kumar Sinha under instructions of Mr. Santosh Kumar seeks permission to withdraw this petition. Accordingly, this counsel for the opposite party has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn. Communicated.
इसमें साइन कर
Item 21, Criminal Revision 448 of 2019.
Your Lordship, in this petition, the revisionist has preferred this criminal revision challenging the order whereby the petition filed in
What is the present stage of the
present
case?
state.
There is a specific order that there is no stay.
There is no stay. Admittedly, there is no stay.
Not admittedly, there is a specific order. However, the court below is directed to proceed accordingly as there is no interim order in this case.
Yes, Your Lordship.
This was passed way back in 2020. What is the present stage of the case?
Your Lordship, I could not.
It is at a stage of arguments.
The stage of arguments. You want to still press it? कुछ adjourn नहीं. कल tomorrow कर सकते. कल कोई तो केस कल डिस्पोजल होना चाहिए. देखिए होली के बाद I don't want any adverse order to be passed against you.
ठीक है, कल revision पूछ लेते हैं.
Criminal Revision 448 of 2019. Counsel for the parties are present. Counsel for the state has informed this court that the case before the learned trial court is at the stage of argument. At this, counsel for the petitioner submits that he shall seek instructions. The matter may be posted tomorrow. Post tomorrow.
Item 22, Criminal Revision 465 of 2019.
This criminal revision will become infructuous and also petition has been executed.
Criminal Revision number 465 of 2019. The learned counsel for the petitioner submits that he does not want to press this criminal revision. Accordingly, this revision is dismissed as not pressed. Communicate. आइए जितना है ना सब में आइए क्लोज कर दीजिए इस प्रोसीजर.
Please.
From daily list for final disposal, item 2, Criminal Revision 36 of 2019.
Yes, petitioner.
May I please your leadership? This matter, the order of conviction is under challenge, your leadership, under the Arms Act. Initially, the FIR was lodged under section 25(1)(a) and 26 of the Arms Act, but it has been convicted only for section 25. Leadership, the two orders are against me. The sole ground, the legal ground which we are taking here is that the accused took the ground of being a person of unsound mind, lunatic, and that was not properly considered by either of them.
At what stage did you take the
PW4, PW5, DW1, Exhibit 1, 2 and 3. Exhibit 1, 2 and 3 are my medical documents of RINPAS which were exhibited, and the
plea is not plea for this unsound mind has to be taken by filing a separate petition.
On that, your leaderships, the 328 and 329 of the CrPC talk about that. For that, your leadership, I will be relying upon a judgment passed by the Honorable Supreme Court recently in the case of
Prakash Naik versus State of Goa.
Did you file any petition?
No, I did not file a petition. I did not file a petition, and the judgment is very clear that a petition is not required. Para 15 and 16 Your Ladyship. Para 15 Your Ladyship, page number, internal page number 9. May I please? Chapter 15 of the Code of Criminal Procedure 1973, though procedural in nature, also becomes substantive when it deals with the accused, with an accused person of unsound mind. A well-laid procedure is contemplated under section 328 to 329 of the CrPC. There is not even a need for an application under section 329 of the CrPC in finding out as to whether an accused would be sound enough to stand a trial. Rather, it is the mandatory duty of the court. Under section 330, the court can even go to the extent of discharging such a person if his inability to strive continues with a rigid chance of improvement. As per section 334 of the CrPC, the judgment of the court shall include a specific finding that the act was committed due to unsoundness of mind, though it was actually done. The reason is as simple that there cannot be an acquittal on the ground of unsoundness of mind unless the act is actually done. The whole idea under the provision discussed is to facilitate a person of unsound mind to stand trial not only because of his reasoning capacity but also to treat as one who is having a disability. The role of the court is to find the remedial measures and to do complete justice, Ladyship. Now, if Ladyships will come to the facts of the present case, PW4 and...
What was the fact of the case that you have cited? That is also required to be seen.
The facts of the case are here stated, Your Ladyship. In this case, he was suffering from schizophrenia.
You just come to para number 1.
1 of the judgment?
Yes, of the judgment.
While acknowledging the hurt that has caused to Latris for causing the death of his father, whom he murdered by way of a mistaken identity, Hamlet pleads temporary madness. While pleading so, he disassociates himself from the act as if it was done by a third person and he was made to suffer the consequence. He thus pleads to treat him as a victim rather than an offender. Though the act of Hamlet does constitute a culpable homicide, coming within the definition of section 300 of the Indian Penal Code 1860, an act of unsound mind would not attract the same. Though these lines Shakespeare bring out the agony of a man having to justify his act of madness. Raising the plea of insanity on the mandate of section 84 of the Indian Penal Code, the appellant seeks reversal of the order of the conviction passed by the Division Bench of the High Court at Bombay, confirming the order of Additional Sessions Judge S.G. Margao 2. As we are dealing with the seminal issue of applicability of section 84 of the IPC, and in light of the focus made by the counsel for the appellate, we do not propose to go into the merits. We have heard Shri so and so. Section 84. Act of a person of an unsound mind. Nothing is an offence which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or he is doing what is either contrary or what is either wrong or contrary to law. Section 84 of the IPC recognizes only an act which could not be termed as an offence. It starts with the words, nothing is an offence. The said words are clear indication of the indictment behind this laudable provision. Such an act also emanates from an unsound mind. Therefore, the existence of an unsound mind is a sign of one known to the applicability of the provision. A mere unsound mind per se would not suffice. It should be to the extent of not knowing the nature of the act. Such a person is incapable of knowing the nature of the said act. Similarly, he does not stand to reason as to whether an act committed is either wrong or contrary to law. Needless to state, the element of incapacity emerging from an unsound mind shall be present at the time of commission. The provision speaks about the act of a person of unsound mind. It is very broad provision relatable to incapacity aforesaid. The test is of the point of view of a prudent
Now
man.
let us see the facts of this.
Yes. Ladyships will see the FIR. If at all the FIR is only seen, it is part of the LCR records, your Ladyships. It would be FI. It is page 21 of the records only.
Who is
The police officer, PW3. PW3. He says that on a basis of a secret information, he received an information that the person is possessing arms and is threatening the villages.
Can you read that?
Yes. निवेदन पूर्वक कहना है कि मैं सअनी मनोज कुमार आज दिनांक 24/1/18 को करीब 10 बजे थाना से दीवागस्ती से सशस्त्र बल के हवलदार सत्यनारायण शर्मा पुलिस सोवनसो उरांव के साथ प्रस्थान किया। दीवागस्ती के क्रम में करीब 14:15 बजे घोड़ाबंदा हाई स्कूल के पास पहुंचा तो मुझे गुप्त सूचना मिली कि घोड़ाबंदा में एक व्यक्ति आर्म्स के साथ गांव में घूम रहा है तथा स्थानीय लोगों को धमका रहा है। इस सूचना का सत्यापन एवं आवश्यक कार्रवाई हेतु सभी सशस्त्र बल के साथ घोड़ाबंद गांव के लिए प्रस्थान किया। सोना हेमब्रम घोड़ाबंद गांव के घर के पास पहुंचा तो वहां एक व्यक्ति को देखकर भागने लगा। उपर्युक्त पुलिस बल के
एक व्यक्ति पुलिस को
देखकर एक व्यक्ति पुलिस को देखकर भागने लगा। उपर्युक्त पुलिस बल के सहयोग से उस व्यक्ति को खदेड़कर पकड़ाए हुए व्यक्ति के नाम पूछने पर अपना नाम कामेश्वर हेमब्रम पिता सुवनसो घोड़ाबंदा बताया। वहां पर उपस्थित ग्रामीण धनेश्वर हेमब्रम PW4 सुवनसो सुदर्शन हेमब्रम PW5 सुवनसो के समक्ष तलाशी नियमों का पालन करते हुए अपनी तलाशी देते हुए पकड़ाए गए व्यक्ति कामेश्वर हेमब्रम का जमा तलाशी लिया तो उसके कमर से एक लोडेड पिस्टल।
What is there to show that he was a person of unsound?
PW4 and PW5 who are independent witness, seizure-less witness. Your ladyships kindly come to PW4 and PW5. Dhaneshwar Hemram. Point number 4
just
it is page number 8, your ladyship, of the examinations.
PW4
Dhaneshwar Hemram. May I place it, your ladyship?
Yes.
Read the full. उपस्थित अभियुक्त जिसका नाम कामेश्वर हेमब्रम है मेरे गांव का है। उपस्थित अभियुक्त मेरे गांव का चाचा है। मैं 10वीं तक पढ़ा हूँ। इस कांड के जब्ती सूची पर मैंने गवाह के रूप में अपना हस्ताक्षर बनाया है जिसे मैं पहचानता हूँ। प्रादेश 1 में अंकित किया गया है। अभियुक्त कामेश्वर हेमब्रम पागल है। अभियुक्त गांव में हल्ला करता रहता है, घूमते रहता है। पुलिस वाले जब गांव में आए तो अभियुक्त के साथ इनकी बाताबाती हुआ था जिसकी उसी कारण अभियुक्त को पुलिस पकड़कर ले गई थी। हम लोग ने पुलिस से कहा था कि ये पागल है फिर भी पकड़कर ले गई। अभियुक्त के पास से कोई सामान बरामद नहीं हुआ था। अभियुक्त को पकड़ने का जो कागज है बना था उसमें मेरा हस्ताक्षर लिया गया था। Then your ladyships would come to the next PW5 Sudarshan Hemram. May I place it? हाँ, सुदर्शन हेमब्रम PW5। मैं स्कूल जाकर 10वीं कक्षा तक की पढ़ाई किया हूँ। मैं मैट्रिक द्वितीय श्रेणी से पास किया हूँ। मैं अपनी परीक्षा मेहनत से पास किया था। उपस्थित अभियुक्त दृष्टि में मेरा भाई लगता है और एक ही गांव के हैं। इस कांड की जब्ती सूची पर मेरा हस्ताक्षर है। मैं पहचानता हूँ जिसे प्रादेश 2/2 अंकित किया गया है। प्रति परीक्षण अभियुक्त मानसिक रोगी, उसका इलाज 2 बार काके में हुआ है। फौज से आने के बाद से ही उसका मानसिक संतुलन बिगड़ गया है। घटना के दिन पुलिस गांव में आई थी एवं अभियुक्त से बाताबाती हुआ था। इसी कारण पुलिस उसे पकड़कर ले गई थी। अभियुक्त के पास से कोई बंदूक नहीं बरामद हुआ था। हम लोगों ने पुलिस से कहा कि अभियुक्त पागल है, उसे छोड़ दीजिए, लेकिन फिर भी पुलिस अपने साथ लेकर गई। पुलिस अभियुक्त को पकड़ ले जाने के दूसरे दिन थाना में बुलाकर कागज में हस्ताक्षर करवाया और कहा कि ये गिरफ्तारी का कागज है। Then ladyships, we also examined one witness DW1.
Yes.
May I place it? DW1 त्रिलोक हेम्ब्रम, कामेश्वर हेम्ब्रम मेरे पिता हैं। मेरे पिता भारतीय सेना में थे। दिमागी हालत ठीक नहीं होने के कारण उनको
DW1 just
DW1
पेज नंबर कौन सा?
पेज नंबर 15. It is not in seriatim ladyship act. That is the problem.
Anyways.
After the order of the sanction, may I place it? DW1 त्रिलोक हेम्ब्रम, कामेश्वर हेम्ब्रम मेरे पिता हैं। मेरे पिता भारतीय सेना में थे। दिमागी हालत ठीक नहीं होने के कारण उनको VRS दे दिया गया। मेरे पिताजी का इलाज 2015 से काकी स्थित रिम्पास में करवा रहा हूँ। मेरे पिता को 11/5/2015 में अस्पताल में भर्ती कराया गया था। 3 माह बाद उन्हें 28/8/2015 को मुक्त किया गया। यह डॉक्टरी पुर्जा डॉक्टर महेश हेम्ब्रम की लिखावट एवं हस्ताक्षर में है, जिसे पहचानता हूँ। प्रादेश A अंकित किया गया है। 2017 में मेरे पिता को फिर इलाज हेतु रिम्पास ले जाया गया था। उस समय वहाँ डॉक्टर नाग जी थे।
2017 में?
हाँ,
एक में नहीं,
17 में पहले है, इंसिडेंट से पहले है। ले गया था। यहाँ पुर्जा उन्हीं के लिखावट एवं हस्ताक्षर में, जिसे पहचानता हूँ, जिसे प्रादेश B में अंकित किया गया है। 2018 में पुनः इलाज हेतु मेरे पिताजी को अस्पताल में ले जाया गया, जहाँ डॉक्टर प्रमिला के द्वारा इलाज किया गया। यह पुर्जरी डॉक्टर है, उन्हीं की लिखावट एवं हस्ताक्षर में है, पहचानता हूँ, जिसे प्रादेश C में अंकित किया है। All 3 medical prescriptions have been exhibited. मेरे पिताजी को बीच में दिमागी दौरा पड़ता है। दिनांक 24/1/18 को भी मेरे पिताजी को दिमागी दौरा पड़ा था। दौरा पड़ने पर मेरे पिताजी उस दिन घर से गाली बकते हुए रोड की तरफ आ गए थे। पीछे पीछे मैं भी दौड़कर गया तो देखा कि पुलिस वाले मेरे पिताजी को अपनी सरकारी जीप में बैठा रहे थे। मैंने पुलिस को बताया कि मेरे पिता का दिमागी हालत ठीक नहीं है, तो वो लोग बोले मुझे डांट कर हटा दिए। पुलिस मारपीट नहीं किए थे, लेकिन जबरदस्ती गाड़ी में बैठा लिए। प्रतिपरीक्षण। आज मैं न्यायालय में आप अपने से आया हूँ। मुझे कोई कोर्ट का नोटिस नहीं मिला था। मैं टाटा कॉलेज चाईबासा में पिछले वर्ष 2017 में पार्ट 1 में नामांकन कराया था। इसके पहले मैं +2 मजगांव विद्यालय में 2015 में कक्षा 11 में नामांकन कराया था। 2016 में मैंने कक्षा 12 पास की थी, लेकिन प्राप्तांक कम था, तो मैंने दोबारा कक्षा 12 की परीक्षा दी थी। वर्ष 2015 से पहले मैं चाईबासा के मांगीलाल रुंगटा विद्यालय में वर्ष 2013 में कक्षा 9 में नामांकन कराया था। उपर्युक्त सभी नामांकन एवं प्राप्तांक का मैं कागजात न्यायालय में दाखिल कर सकता हूँ। मेरे घर में मैं बड़ा लड़का हूँ और मेरे से 2 छोटे भाई और एक छोटी बहन है। मेरे घर में खेती बाड़ी है, परंतु मैं ये नहीं बता सकता कि कितनी खेती बाड़ी है। मेरी खेती बाड़ी का कागज मेरे पास नहीं है। पुनः कहते हैं कि मेरे पास कागज है, परंतु सभी कागज नहीं है। मैं खेती बाड़ी करता हूँ। मैं घर चलाने के लिए खेती बाड़ी करता हूँ। मेरे पिताजी रोजाना 6 दवा खाते हैं, और जब दवा खाते हैं तो ठीक रहते हैं। मेरे पिताजी को वर्ष
What document has been exhibited that he was in army and he was
no document has been because
there is cross examination on this.
He was granted VRS.
No, from where do you say this? There is no document. He has been cross examined on this. He says that I have no document.
There is no document which has been presented in defense. So that is not would be of much.
Because you see the credential of a person becomes equally important. Right? He was from army. He took VRS. Any proceeding initiated. Maybe that he was compulsorily retired.
On that also the DW1 is saying that
mere statement is not sufficient. Mere statement is a person who is taking VRS must be having some I-card of army. He is entitled to for so many kind of medical facilities and pension and so many things. Nothing has been produced.
It is not on record.
So it has not been established that he was from army.
To some extent, yes, it can be said. Obviously, from the records, it will be apparent that it was not established beyond reasonable doubt. But
no, it is not a matter of establishment beyond reasonable doubt. Where a person asserts that I am a retired person or having taken VRS, and he is being cross-examined on this.
Your leaderships would appreciate.
Anyways, we will see that. So there is admittedly no document regarding his regarding this person belonging to army. No document.
No document on record.
And cross-examined.
Cross-examined. Yes, DW1, his son has been cross-examined, and he has also, if your ladyship's will permit me, I can put further also. he has said it कि there are no documents and कोई departmental proceeding भी हुआ है कि नहीं हुआ मुझे कोई जानकारी नहीं. Also, Your Ladyship, I would like to place one judgment of our honorable court from the division bench.
No, not judgment. You just place the facts first.
Also,
judgments are applicable on facts.
Applicable on facts, yes. So, PW4, PW5, DW1 and the medical documents have been consistent enough that he had some kind of medical issue with regards to unsoundness of mind. Now, when we apply 329 or 328 or
these are, you just read the deposition of the informant.
Informant is again PW3 and he has stated nothing. I will just place it. PW3 is informant Manoj Kumar. दिनांक 24/1/18 को मैं मजगांव थाना में सअनी के पद पर पदस्थापित था. उक्त तिथि को प्रत्येक दिन की तरह मैं दिन के 10 बजे थाने के दिवागश्ती के लिए निकला. मेरे साथ एक हवलदार और 3 सिपाही थे. दिवागश्ती के लिए थाने के सरकारी वाहन से प्रस्थान किया. दिवागश्ती के क्रम में लगभग 14:15 बजे घोड़ाबंदा हाई स्कूल के पास पहुंचा तो मुझे गुप्त सूचना मिली कि घोड़ाबंदा में एक व्यक्ति पिस्तौल लेकर घूम रहा था तथा लोगों को डरा धमका रहा था. गुप्त सूचना मिलने के पश्चात मैं अपने सशस्त्र बल के साथ घटनास्थल पहुंचा तो एक व्यक्ति पुलिस बल को देखकर भागने लगा तो उस सशस्त्र बल के सहयोग से पीछा करते हुए सानूराम हेमब्रम के घर के पास पकड़ा गया. पकड़ा व्यक्ति ने उसका नाम पूछा गया तो अपना नाम कामेश्वर हेमब्रम बताया. 2 स्वतंत्र गवाह के समक्ष अपनी जमा तलाशी दिया. उसके पश्चात पकड़ा व्यक्ति कामेश्वर हेमब्रम का तलाशी लिया तो उसके बाइक कमर से एक देसी 6 चक्र का पिस्तौल बरामद हुआ. बरामद पिस्तौल को खोलने पर 2 गोली मिला जिसमें से एक गोली का बेंदा पर ठोकर लगा हुआ था तथा दूसरी गोली जिंदा थी. बरामद पिस्तौल एवं गोली के संबंध में पूछे पकड़ाए व्यक्ति ने कोई स्पष्ट जवाब नहीं दिया. तब मैंने वहां उपस्थित 2 स्वतंत्र गवाह धनेश्वर हेमब्रम और सुदर्शन हेमब्रम की समस्त जब्ती सूची बनाई. PW4 और PW5. घटनास्थल पर ही मैंने अपना एक स्वलिखित बयान तैयार किया. यह वही स्वलिखित बयान है जो मेरे लिखावट एवं हस्ताक्षर में है जिसे मैं पहचानता हूँ जिसे प्रादर्श 1 में अंकित किया गया है. इस कांड की जब्ती सह तलाशी सूची मेरे लिखावट एवं हस्ताक्षर में है जिस पर दोनों स्वतंत्र साक्षियों ने मेरे समक्ष हस्ताक्षर किया है तथा उनके हस्ताक्षर को भी मैं पहचानता हूँ. पूरे जब्ती सह तलाशी सूची को प्रादर्श 2 में अंकित किया गया है. उसके बाद पकड़ाए व्यक्ति को विधिवत गिरफ्तार किया गया एवं घटनास्थल पर ही गिरफ्तारी ज्ञापन तैयार किया. यह गिरफ्तारी ज्ञापन पकड़ाए गए व्यक्ति कामेश्वर हेमब्रम की पत्नी एवं बेटी के समक्ष तैयार किया जो मेरे लिखावट एवं हस्ताक्षर में है एवं अभियुक्त कामेश्वर हेमब्रम की पत्नी और बेटी ने मेरे समक्ष हस्ताक्षर एवं टिक का निशान दिया जिसे मैं पहचानता हूँ. इस गिरफ्तारी ज्ञापन को प्रादर्श 3 में अंकित किया गया. गिरफ्तारी व्यक्ति एवं जब्त पिस्तौल एवं गोली के साथ थाना को लेकर सुपर्द कर दिया. उपस्थित अभियुक्त कामेश्वर हेमब्रम को मैं पहचानता हूँ. प्रतिपरीक्षण. अभियुक्त कामेश्वर हेमब्रम की पत्नी एवं बेटी मेरे समक्ष यह नहीं कहा था कि अभियुक्त पागल है. अभियुक्त के द्वारा किन किन ग्रामीणों को धमकाया गया उनका नाम मुझे नहीं मालूम है. अभियुक्त ग्रामीणों को क्यों धमकाया गया यह भी नहीं मालूम. जब प्रादर्श को रुमाल में लपेटकर थाना लाया था. प्रादर्श 1 जब्ती सूची पर अभियुक्त का हस्ताक्षर नहीं है क्योंकि उसका जरूरत नहीं है. गिरफ्तारी ज्ञापन का प्रारूप एवं जब्ती सह तलाशी सूची का प्रारूप अभी मेरे पास नहीं है क्योंकि उसे मैं लेकर नहीं चलता हूँ. प्रादर्श 1 एवं 2 पूरी घटनास्थल पर ही लिखा गया था. थाना में आकर उसमें कोई लिखा पढ़ी नहीं किया गया था ना ही कोई फेरबदल किया गया था. थाना लौटने के बाद केवल कांड दर्ज किया गया था. ऐसी बात नहीं है कि अभियुक्त पागल है तथा पुलिस से बाताबाती होने के कारण झूठा केस में फंसाया. So this was a suggestion also taken from him. And all the PWs have stated a suggestion was taken from all of them consistently. PW1, PW2, PW7, PW8. And leaderships in his 313 also, when a question was put forth to him, सफाई में क्या कहना है, तो वो कहते हैं कि निर्दोष को पुलिस के साथ बहस हो गया था जिसके कारण मुझे फंसा दिया गया. The entire gamut is basically a small dispute between the police and the petitioner, your leadership. This
Is it legally permissible to move around? Did he have any license?
No, license.
License.
Again.
From where did he get this?
Again, your ladyship. Now, when the Caesar list witnesses have clearly stated in the cross-examination that
Just a moment. Don't shift from one point to another point. In the opening sentence, you say that the only point is unsound mind.
Definitely, that is a legal point. But again, I will not leave this point also that Caesar list witness PW 4 and 5 who are independent witnesses, and the police is also saying that they are independent witnesses, and they are clearly stating that no recovery was made and they have not been declared hostile by the prosecution.
That's right.
They have not been declared hostile by the prosecution.
Where is his statement recorded under 313?
313, your ladyship, would be at page number 31.
and 32.
31 and 32, yes, running 31. Starts from 31. 32 is 218, your ladyship, and this is 313 is 31. May I place it? क्या आपने साक्षियों का साक्ष्य सुना? जी हाँ। आपके विरुद्ध यह साक्ष्य है कि दिनांक 24/1/18 को शस्त्र के साथ अपने गांव में घूमकर लोगों को धमका रहे थे। इस संबंध में आपको क्या कहना है? जी नहीं। आपके विरुद्ध यह साक्ष्य है कि पुलिस बल के द्वारा आपको पकड़ाया गया तथा तलाशी नियमों का पालन करते हुए आपकी तलाशी ली गई, जिससे आपके बाई कमर से लोडेड पिस्टल 6 चक्र का बरामद हुआ। इस संबंध में क्या कहना है? जी नहीं। आपके विरुद्ध यह साक्ष्य है कि लोडेड पिस्टल पुलिस बल को के द्वारा खोलने पर 2 गोली बरामद हुआ, जिसमें
Now let us see the I've read it. Yes, let us see the findings of the learned trial court and the appellate on both the points, on the point of Caesar and on the point of his unsound. State is not there; they are not interested.
Last occasion also nobody was there for state, your ladyship.
We'll pass the order in their absence. If they don't want to be there, let them not be there.
The magistrate court order, it starts from page number 33.
You just come to the findings in connection with search and seizure and madness. Did you take the plea before the learned trial court as well as the appellate court that he is of unsound mind?
Yes.
Kindly come to those 2 findings only. I just want to see 2 findings of the learned court with regard to unsoundness of mind and with regard to seizure.
Ladyship, this judgment, the magistrate court judgment, basically the paragraph 9 would be my defense. Page number 36. In fact, paragraph from 8, paragraph number 8, internal page 4, page number 36 of the revision petition, and internal page 4 of the order.
Yes.
The defense has produced 3 prescriptions of written pass which are marked as exhibits A, B and C respectively. The learned defense counsel has submitted that the accused Kameshwar Hindram is an unsound person, and at the time of alleged occurrence he was not in position to understand the facts and he was under control of mental doctor at Ranchi. The defense has produced the documents which are marked as exhibit A, B and C. On perusal, it appears that the accused Kameshwar Hindram was under treatment since 2012 from written pass. The defense has produced 1 witness in support of the document who is son of the accused. He deposed before the court that earlier his father was employed in Indian forces and he has taken VRS on the ground of unsound mind. His father was under treatment since 11/5/2015. On the day of alleged occurrence, his father got mental disimbalance, due to which they fled away from the house after abusing. He chased him, but he saw the police person has taken him in custody and brought to police station. He requested his father's mental condition is not proper, but they chided him. During cross-examination, he deposed in para 6 that his father regularly takes 6 medicines per day. When he takes medicines, his mental condition was good. He has not filed any document regarding VRS. He is not an expert, so he is not able to disclose regarding treatment. He wants to save his father from the case. The learned defense counsel further submitted that he has produced the relevant documents regarding unsoundness of mind, so he deserves to be acquitted from his case on the ground of unsound mind. So this plea was taken and learned APP. Now, Page number 37, leadership's the second paragraph. The defense has not filed
You
any.
read the learned APP also.
Oh, the learned APP has submitted that the defense has not chosen to exact provisions provided under the CrPC and the accused was found in normal condition during the whole trial. The occurrence has taken place on 24/1/18 and the defense has failed to produce any documents to show that the accused was taken the medicine from Rinpas Rachi Kaki in the year 2018. So the version of the defense is not believable and it does not deserve to take the benefit of uncertainty. The defense has not filed any petition to examine the accused by a competent medical officer and to postpone the proceeding which is initiated against the accused. The defense has to invoke the provisions under section 329. May I read 329?
We have read it. You just proceed further.
Does I find and hold that the plea of alibi taken by the defense is not believable because the defense has not produced any medical officer to corroborate the prescriptions produced by the defense and the defense has not taken proper forum which are available under 320 and 329 of the CrPC. So this was my ground of rejection for not accepting that the petitioner was suffering from unsoundness of mind.
Why no doctor was produced from your side?
No doctor was produced. There is maybe not knowing it, maybe not understanding the legal arenas. No doctor was produced. That is a fact that no doctor was produced. But 329, your leaderships, if your leaderships pleases, I would like to state that even if a prudent, a reasonable prudent person who proves it or brings forth the defense, then the burden shifts to the prosecution. If I'm taking this defense has to be proved by me, but it has to be proved only on the basis of prudency, a prudent person. That is what 329 says.
So any person who is not acting in a prudent manner is a person of unsound mind.
No, that's not what I want to say in leadership. I want to place that if I am suffering from a mental illness, unsoundness of mind, or being lunatic.
What is the authority on this point?
The judgment says.
That we have read.
And another judgment, if your leaderships will allow me to quote.
Yes.
This judgment is of our Honorable High Court only. It was a criminal appeal DV matter, wherein in the DV matter itself, the Honorable Court directed for a medical test.
Here we can't ask.
I'm just stating that in this matter, it was a death reference. He killed 8 persons.
That is a separate thing altogether. Here, a plea has been taken. It is being considered by the trial court. Trial court says 2 reasons. One, that the trial court is not convinced with your plea of unsound mind, and secondly, no petition was or no steps was taken.
But then, if the trial court is saying so, a trial court is bound to conduct a preliminary inquiry first. Stop the proceedings. 329 is very clear, your ladyship, and conduct a preliminary inquiry. And
provided the initial burden is discharged.
Now initial burden is discharged from the factum that 3 applications of RINPAS are being produced, PW4 who is an independent witness, PW5 who is again an independent witness, DW1 can be said to be an interested witness, but PW4 and 5 who are Caesar-less witness, independent witness, have clearly said that वो पागल है, वो घूमता रहता है. So when a substantial amount of reasonably it has been shown, it was the duty of the learned.
They are also unsound mind by putting signature on blank papers.
Again, that
because you see the conduct of these 2 witnesses, they are totally denied the Caesar completely.
But then they have not been declared hostile by the prosecution.
That is okay.
Yes.
That we will take care of.
So that they have not been declared. So
now you said what is the finding of the appellate court on this?
Appellate court also says the same. You know, leadership, if I be permitted to place it. The appellate court judgment starts from page number 21 of my petition. And Paragraph number 12, internal page 8.
Where is the finding?
That's
Regarding
the
answer.
finding.
Internal page 8.
Internal page 8. My petition 28.
Yes.
The main argument of defense is insanity of the appellant, but during cross of trial or appeal, defense has not filed any petition to examine the appellant by a competent medical officer to postpone the proceeding, which is initiated against the accused appellant before the trial court or before this court at the time of hearing of this appeal. The defense has also not invoked the provision contemplated under section 329 so and so. In view then the provision.
So at any stage,
we
application
did not
was
file
filed.
an application. Yes, that is an admitted position. I cannot go beyond that. We did not file an application. Yes, we filed our prescriptions, which is an exhibited document, and witnesses to that extent. These two steps.
There is a finding regarding search and seizure.
There is no finding. There is no finding by any of the court.
In a case of Arms Act,
your ladyship can see.
Without any finding, how can the person be convicted for possessing arms?
The state can explain it, your ladyship.
Let us see the order of the trial court.
Yes.
How is it possible? Para number 13.
Para number
13.
In this case, the prosecution has alleged against the accused Kameshwar Hemra that secret information received by the informant, who is PW3, has proceeded towards the place of occurrence and find one person holding arms want to flee away after seeing the police party. But anyhow, he was apprehended. On search, one country-made revolver having 2 cartridges in which one live and another was coca. The sergeant major, who is PW7, has opined that searched arms and cartridges were dangerous for human life. The version of the defense is already disclosed in detail and his alibi is not sustainable in this case. The district magistrate West Singhbhum has sanctioned for launching prosecution under the Arms Act against the accused Kameshwar Hemram after going through the report of sergeant major and the arms produced before him. All PWs have deposed that accused Kameshwar Hemram was moving with arms. PW 4 and 5, who are Caesar list witness, are relative and co-villagers, hence they are interested witness. They are literate person, but they have not informed the matter before any higher authority of the police administration regarding illegal work done by the Majgaon PS as they alleged. No one has prevented them to disclose the matter regarding unsoundness of mind before any higher authority or before the court during the trial. When the defense has put the question, then they disclose that the accused is insane person. So the version of these 2 witnesses is not believable. The defense has taken only plea for alibi, which was discarded earlier. The defense has not produced any document to show that the accused holding the arms with a valid document. Thus, I find and hold that the prosecution is able to establish its charges for offences under section 25(1)(ba) Arms Act against the accused Kameshwar Hemram.
So you cannot say that there is no discussion about Caesar.
A bit.
See, when you make a statement, no discussion, it means it's a very bold statement.
I take back that, your ladyship. I missed it. I take back that. But your ladyship needs to appreciate the fact that even if they are the trial
appellate court. Internal page 9.
Internal page 9, yes, your ladyship. In view of the aforementioned principles as well as evidence of DW1 Trilok Hemram and witnesses of facts, it is clear that at the time of arrest, the appellant was not insane and was mentally sound. The trial court has now found the type of insanity the accused during trial. The appellant has not claimed his insanity as a defense, then his statement under 313 was recorded. Hence, the contention of learned counsel for defense regarding unsound mind of the appellant holds no much more. The learned counsel for the appellant centers about search and seizure of illegal country-made 6-round revolver and cartridges allegedly recovered from the possession of accused appellant. Seized materials were kept in police custody for a considerable long period. As such, there was chance of tampering and manipulation. In this connection, there is a clear-cut evidence PW3 ASI, that is the informant of Majgaon, that prior to conducting search, he gave his own search. Therefore, conducted body search of accused Kameshwar Hindran in presence of two independent witnesses. He seized one country-made pistol revolver from the waist of accused, and after opening the revolver, he found two cartridges, out of which one has tampered and another was live. From perusal of the seizure list, Exhibit 2, it is crystal clear that the loaded cartridges in the country-made revolver was of 7.65 on the bottom, of which KF was inscribed. The seizure list was prepared on 24.
The appellate court has also considered it.
What I'm saying is,
on the point of seizure, a finding has been recorded. It is one thing to say that the finding is not correct, and it is another thing to say that there is no finding.
Your ladyship, merely stating that they have PW3 has stated that is there.
It is not a case of no finding.
It is not a case of no finding. It is not a case of no finding.
Yes, respondent.
During the learned trial court has given its finding with regard to the recovery of the arms without from the without possession of the petitioner.
No, that is not sufficient. If the finding is conclusive and binding, that's the matter ends. But the point is that two witnesses who were seizure list witnesses, they deposed that there was no recovery, and they have also stated that their signature is admitted, but they have not been declared hostile.
The seizure list witnesses has not
And
admitted
a copy of the seizure list was not handed over to the accused.
That is an error.
Very serious error. It's a very serious error.
Under the Arms Act note, the law is very clear that under the Arms Act, the seizure and the sealing of and proper identification marks over
Yes.
the arms is
And a copy, and the IO says that there is no requirement in law to hand over the copy of the seizure document to the accused.
It's not.
The seizure is not proved. In insanity, I am not agreeable with it. But seizure is not proved.
But the seizure
Certainly
is
seizure
witnessed
is
if
not.
the contents of the seizure is not has been denied by the seizure witness.
Yes, not declared hostile also.
Yes,
give him the LCR. लिखिए आप तो थे नहीं दीजिए अब दीजिए. इनको एविडेंस आप 3 एविडेंस पढ़ लीजिए, ठीक है? Informant का एविडेंस who is a police officer and 2 seizure list witnesses, and tell us whether the seizure is proved or not.
The paragraph 7 Lord he has said Lord that it is not required. It is wrong.
Absolutely wrong. Now you have to give me some judgment also on this. आप ही लेके गलत है ना? इसको हम लोग को रेक्टिफाई करना जरूरी है. This is the understanding of your police.
ये कह रहे हैं कि रिक्वायरमेंट नहीं है सीजर लिस्ट में इनका सिग्नेचर इज नॉट रिक्वायर्ड. वहाँ गलत है. But if the seizure is witnesses in whose presence the seizure is made, and if they turn hostile during the trial, but they admits their signature over the seizure list, the witnesses admits the seizing authority, the person, the officer who has prepared the seizure list, if he has proved their seizure list,
hostile तो declare करना था ना.
नहीं हुए हैं.
तो it's very serious.
Hostile.
If the witness has not been, we can understand that seizure list witnesses can become hostile. They may be relative, neighbor, or n number of reasons. But once they have not been declared hostile, then their evidence has to be taken into consideration.
Yes, of course.
Then
This evidence is intact. No?
his
So
evidence
whether
is intact, examination and cross-examination both. So the seizure is not proved.
Not only this seizure is not other from their side. I am seeing that here in the informant version does not speaks about the sealing at the place of occurrence. Your Lordship has also held in numerous judgment that at the point of
How the seizure has to be
and
made,
because in
how
arm
the
set-
sealing is to be done.
Yes, at the place of occurrence.
At
In
the
the place
place
of
of
occurrence, there
occurrence.
is chance of not the manipulation in the, and so therefore the identification, distinct identification marks over the seized arms.
That has also not been done.
Yes, that on that basis, Lordship has acquitted so many.
एक तो जजमेंट लेके आइए, हम तो भूल गए. इनको तो टाइम नहीं है रिसर्च करने का. आप ही करिए. सेकेंड हाफ में लिखाते हैं. आप ले आइए प्लीज, दो चीज़ ले आइए. सीजर लिस्ट पर, सीजर पर एक आध जजमेंट हम किए हैं. आप लिखिए. But so far as insanity is concerned, she has relied upon one judgment.
No petition has also been.
No, अभी एक कोई नया judgment आया है. That petition need not be, is not necessary. But if by virtue of preponderance of probability, if by virtue of preponderance of probability, the person discharges, substantiates that yes, there was an element of insanity, then
it ought to have been inquired.
Irrespective of
and after staying the proceeding, the requirement of law under section 329 that the inquiry with regard to the elements has to be.
Yes. And no prescription was produced?
No, 3 prescription of written pass.
Let us see the exhibits also.
Yes. I'll just place it. Page number 28, just after the order of the sanction, is the first prescription.
Yes.
It has been received in Upper Mukh Nyaya Dandadhikari 25 July 2018. And the second one is at page number 29.
And what is the date of the incident?
One is 11/5/2015.
Date of the incident.
Date of incident 24/1/18. Prescriptions are dated 11/5/15, 22/5/17, and one is 12/7. उसमें year वो Xerox में कुछ हुआ है memberships में document में, but it has been exhibited in the court of ACJ on 27/7/18.
Where is the prescription of 2015?
11/5/15.
Where is that?
And date, page number 28.
28 is 15 or 18? It is 15. No, 18.
15/5, date of admission 15/5/15, and date of discharge is 22/8/15. If you leaderships.
Yearly number. Okay, date of admission. Okay, 11/5/15.
Date of discharge, he was admitted for few months in class.
And rest is under OPD.
No, एक में नीचे हाँ सिग्नेचर है 22/5/17 का.
Rest में admission नहीं है.
हाँ admission.
Only for one admission is there.
For few months from May to August.
The date of discharge. Upon seeing the police, he ran away.
As per the prosecution story. Informant who is also a police officer.
So he is
And
aware of what conduct, that his conduct is objectionable.
Again,
He is aware that his conduct is objectionable.
yes, your Lordship, if at all talking in that context, that his conduct is objectionable or why is he running, with all the PWs, a suggestion has been taken from them that there was some dispute between the police and the petitioner. कुछ बाता-बाती हुआ था. All of them have said.
आप जजमेंट ले आइए. सेकेंड हाफ में इसको लिखाएंगे. कॉल करिए.
सीरियल नंबर 1 में जो 1 बजे फिक्स किया पता करवाया सेवरल मोड से कंप्यूटर में अगर जीआर से मिल रहा है ना
पता नहीं चल रहा
है ना SC/ST केस नंबर से मिल रहा है. 12 के बाद कोई अपलोड ही नहीं है लातेहार वाला.
इस केस का कोई अपलोडिंग नहीं है.
12 के बाद कहीं सर्च करवाए हैं.
सीरियल नंबर 1 में सप्लीमेंट्री में ना
जी
ऑफिस इज डायरेक्टेड टू कॉल फॉर द status of the case from the court concerned. Status मंगा लेते हैं, कम से कम रिकॉर्ड तो ऊपर हो जाएगा, तो पता चलेगा ये पड़ा हुआ है.
Phosphorus case item 8 criminal division 309 of 2019.
Commission, you are permitted to withdraw this one.
Criminal Division number 309 of 2019. Learned counsel for the petitioner MS Rajni Singh seeks permission to withdraw this petition. She submits that trial has commenced
Instructions
on instructions of Mr. Kaushik Sarkhe. She submits that the trial has already commenced. Considering the submissions, this petition is dismissed as withdrawn. However, withdrawal of this petition will not prejudice the case of the petitioner in any manner before the learned trial. And liberty is reserved with the petitioner to raise all points which have been raised in this petition and any other point which may be available to the petitioner to communicate.
You are permitted to for serial number 30, 31 and 32. In similar matter, your Lordship has date 15/4/2024. They have not filed counter appeal by the state in spite of your judgment. They will certainly take time for counter appeal. इस केस में also may be 15/4.
देखते हैं, ऐसे नहीं होगा, आप रुक जाइए.
Item 4, the rupees 421 of 2023.
Yes, petitioner.
Minor pay for possible.
The counsel for the petitioner. ठीक है, देखते हैं. अब छुट्टी बात करिएगा, क्या है अभी आपको पास ओवर चाहिए सेकेंड हाफ में, क्या करें, कब करें बताइए, डेट आप बताइए. 2:15 बजे हम डिक्टेशन के लिए रखे हैं, हम नहीं कुछ बोल पाएंगे, आप छुट्टी के बाद करें. काउंसिल फॉर द पिटीशन सीक्स एडजर्नमेंट. Post this case on 30th April.
Water speed defect item 5, criminal division 626 of 2021.
In this case, this offence is under section 498. We have compromised. There is defect regarding posting minutes. We'll pay it within course of the day. A date may be fixed minutes after.
You have filed your joint compromise petition.
But that IA is also not there. So I will be filing it.
There is OP number 2.
Yes.
It has been compromised.
So for that, we have to file an IA and requisite court fee is also to be paid.
It is only 498A.
Yes,
And 3 and 4 also. You have separated or you are living together?
Living together.
It is 498A only?
Yes, ma'am.
Learned counsel for the petitioner undertakes to remove the surviving defect by tomorrow. Preemptory. Counsel for the petitioner and OP number 2 have submitted that the parties have entered into compromise during the pendency of this case and they undertake to file a joint compromise petition.
Exception from surrender minutes and IA for compromise, both is to
What is
IA for exception is to be filed. If it is not filed, then he'll have to surrender.
But you never pointed out.
I'm submitting minutes that.
After I started dictating the
sir.
order and once the preemptory order was passed.
No, I'm sorry, since
You better be sorry for yourself. Yes? There is no petition. There is no petition for surrender.
IA is ready, minutes.
We do not know. We do not know. IA is ready?
Yes, minutes.
Where is it?
It is with me, minutes. It is only to be filed.
What have you stated in your IA?
Minutes that the matter has been settled between the parties. And
Where is the terms of settlement?
Minutes we have annexed in files.
Show us.
Both IAs.
फाइल करिए.
By tomorrow we'll be filing.
लाइए दिखाइए. क्या टर्म्स ऑफ सेटलमेंट है? क्या है टर्म्स ऑफ सेटलमेंट आपके? Where is the terms of settlement?
Minutes IA for compromise we have stated in IA for compromise minutes. This paragraph 6 and 7 minutes. Paragraph 4 we have stated that they both are residing and are enjoying the conjugal life.
पहला चीज़ ये है कि आपका पिटीशन रेडी हो गया, एफिडेविट हो चुका है.
No, minutes. It is not affidavit.
सादा कागज में साइन है. Ask the petitioner and the opposite party to join online. ऐसे हम नहीं मानेंगे कॉम्प्रोमाइज आपका सादा कागज.
आप लोग होली कर दीजिए.
हाँ, होली हम आफ्टर कर देंगे. लेकिन ज्वाइन ऑनलाइन नहीं करेंगे तो हम ऑर्डर नहीं करेंगे. ये जो सादा कागज का साइन करने का तरीका है ना, इस हाईकोर्ट का, इस तरह के जॉइंट कॉम्प्रोमाइज में यू शुड कॉल द पार्टी फॉर एफिडेविट. कमिंग मींस व्हाट?
एडवोकेट क्लर्क जो क्या किया, एडवोकेट क्लर्क इसको मिसिंग कर दिया.
कहानी आप हमको मत सुनाइए. ये हम लोग हाई कोर्ट में ना, आप जितना प्रैक्टिस किए हैं ना उससे कहीं ज़्यादा प्रैक्टिस किए, इसलिए इस हाई कोर्ट का प्रैक्टिस हमको मत सिखाइएगा, ठीक है? मत सिखाइए. We have come across many varied kind of instances. Joint compromise में the party should appear. This is for your benefit. और आइडेंटिटी भी बहुत ज़्यादा ध्यान से देखने की ज़रूरत है. In one case I remember आप एक्यूज अपनी सिस्टर को ले आया वाइफ बनाकर. हाँ, बता रहे हैं हम आपको.
Yes, ma'am.
हो सकता है.
हो सकता है ना.
जिस दिन मान डेट फिक्स किया तो उस दिन उनको दोनों को बुला लेते हैं, अच्छा रहेगा.
या हम नहीं ऑनलाइन भी करा देंगे तो ठीक है.
Yes, we'll ask him to join. They will be here, minutes. It will be affidavit.
If they are here, it's okay.
They'll be here.
यहाँ पे सब एडवोकेट को पता है. और देखिए हमसे झूठ और गलत मत बोला. My mind gets absolutely, it goes to your as a counsel. Why did you say that the only surviving defect is regarding court fees?
I could not point out because your lordship was dictating order.
No, I heard you and then I was dictating. When I passed the preemptory order, you said that surrender certificate is wanting. ये सब सीक्वेंस हम भूलते नहीं, आपको एकदम याद रहता है. केस भूल जाते हैं लेकिन एडवोकेट का ये चीज़ हम कभी नहीं भूलते. प्लीज डोंट डू दिस. हम ऐसे ही अटेंड कर देते।
Yeah.
क्या मतलब है आप लोग का इससे? Why do you need to do all this?
Well, I apologize, Malak. That was not my intention. I just indicated that there is a defect. The Lordship started dictating order, therefore I could not.
You said आप ना घर पे जाके थोड़ा अपना वीडियो घुमा लीजिएगा, ये सब रिकॉर्डेड प्रोसीडिंग्स है ना? ये सारा रिकॉर्डेड यूट्यूब में है। कोर्ट नंबर 11 का सारा प्रोसीडिंग यूट्यूब में है। हाँ, इसीलिए ये सब नहीं चलेगा यहाँ, एकदम नहीं चलेगा। मेरी गलती होगी तो हम मान लेंगे, हमको कोई प्रॉब्लम नहीं है। No, I can admit my mistake also. There is no problem. There can always be a mistake. इसीलिए be very very careful when you make a statement in this court. Right? Criminal Revision number 626 of 2021. Counsel for the parties are present. Counsel for the parties have submitted that the petitioner and opposite party number 2 have entered into out of court settlement and they are living together. They submit that they will be filing their joint compromise petition. The counsel for the petitioner has also submitted that the required court fees will be filed by tomorrow. He also submits that a petition for exempting the petitioner from surrendering will also be filed. Prior to the next date of hearing. Pose this case on 18th of April 2024. Joint compromise petition, if any, should be filed by 10th of April. And the petitioner and opposite party number 2 are directed to remain present before this court. On the next date, if any joint compromise petition is filed.
Yes.